Further hearing in the appeals, Warner-Lambert Company and Generics UK Limited, and another.
Yes, morning. My learned friend reviews. The legal assumption asked me for a note summarising on the page that I was making in my submission about the logical fallacy. Please have on your desk that note. It sets out at the beginning what we say the framework from SALT is, so the analysis down to step 1 and step 2. Explains that the way my friend puts his case in his reply case, that's paragraph 33, is to assert that he gets home on step 1, but explains the way in which he seeks to do that, and that's issues A and B. And the logical fallacy, my lord, is explained in the last paragraph. It is that just because it's a conceivable explanation, in the sense that the data doesn't exclude the possibility, he concludes that that is the explanation. And as I go on...
Or that it may plausibly be.
No, because plausibility is the therapeutic effect. It has to be the direct effect for SALT.
I see, yes. Right.
But in any event, the same argument would apply. But that may be quite...
I mean, is the point that you're making as simple as this? I mean, simplicity isn't a vice. That the fact that you identify a common feature of two phenomena does not mean that it has any causative implications for either. I mean, this is Lord Hoffman's famous joke about the proof that Henry of Monmouth was the same as Alexander of Macedon.
Exactly the point, and the consequence here is I identify in very last sentence, standing back from this particular case and putting it just in terms of condition A, that in effect the logic of identifying conceivable explanations is that you're concluding that they're all right, and it would enable...
Or that any of them may be.
Certainly, but in terms of the disclosure, it would enable you to say that all of them are right, and then you would be able to say that each and every mechanism, I can extend that and say that every condition, any one of them, is plausible. That must be my friend's case, and that's the logical fallacy.
Well, I suppose it's certainly plausible that one of them works, and you haven't dealt with Dr. Remind me of his name, Scadding's evidence that, as far as he was concerned, it was...
I did in my submissions. I was just trying to make explain very simply what the logical fallacy is here. I took you through...
Well, I mean, one understands the logical fallacy, but it all depends what you mean by plausible. If it's one of two possibilities, can it be said to be plausible? One assumes Dr. Scadding thought it could be. It depends what meaning you put on it, doesn't it?
Well, the submissions that I made yesterday, that Dr. Scadding certainly when he said credible, was no more than his conceivable explanation.
Yes, well, is that enough, is the question. I mean, I know you put, at your highest, you put it much higher. You say it's got to be, it's got to join the prior art and show that the thing is obvious. But if one rejects that in the light of authority, both in this jurisdiction and in the European patent organisation and tribunal, then one is asking, what does plausible mean?
My submission is quite clear that if you try and go this indirect route in SALT, you've got to show a direct effect of the drug on the mechanism.
Also, I think your submission has got to show that the connection, or at least some reason for supposing that it may be the answer, has got to be disclosed in the patent.
Yes.
I mean, as I understand it, your main point is that even if all this is good science, it's not disclosed.
Exactly.
I mean, this isn't, as I understand it, necessarily tied to your argument that plausibility is the same test as obviousness.
No.
It's a separate point.
Quite freestanding point, just looking at SALT.
Yeah, well, that obviously, if the two are tied together, then you win hands down. But I mean, we can't treat Salk as the gospel, can we, in the light of the authorities in the appellant's case, at paragraph, in particular paragraph 111, but also 109. It's Justice Henry Carr's decision in Activist and Lilly in this jurisdiction, and I would have thought most important of all, the Bristol-Myers Squibb decision of the board.
That's the separate point of whether or not the standard of obviousness is the same as plausibility.
Right, but I mean, in emphasising that it isn't, it's demonstrating a lower standard, and that's what we're arguing about. What does plausible mean? Does it mean a pretty clear pointer in only one direction, or can something be said to be plausible if it's one out of two possibilities?
Quite separate points, as my Lord Reid just put to me. I explained to my Lord yesterday why it is necessary it's aligned. And I hope I made it clear that that was a matter of debate in patent law. So there are authorities going to say it has to be. The point I've just been addressing is, quite regardless of that, just look at Salk and it tells you what you've got to do in this indirect way. And my friend has a logical fallacy in the way that he seeks to establish step one.
Do you also say that if you are wholly dependent on common general knowledge to make good a connection that isn't disclosed in the patent, that in that case the allegedly inventive step must be obvious? Or is that too simple-minded?
It's too simple-minded. I can't go that far because the addition from
The patent can say, try this. It may not have been obvious to try this, but once you try it, it's then obvious that it works. Is that the...
Well, my submission is, if the certainly on the standard being the same as obviousness, it's got to be as good.
Mr. Speck, would you ask your solicitors to be good enough to make this available in electronic form?
Well, we will do so.
Thank you.
And we can either hand it in memory stick or email it to the registry.
Email will be fine. Thank you.
While we're on homework, you mentioned yesterday, and it was a very effective deterrent, at least as far as I'm concerned, that one had to trawl through lots of rather opaque regulations in order to discover exactly what was and what was not allowed to be on the label. With regret, can I please ask you to supply in due course after the hearing a note on how the regulations impact on what the
SMPC and
well, particularly what I'm obviously particularly interested in is how much further can the generic company go in saying something is not for the patented indication without running into difficulties with the regulations.
we'll do that. I've got a feeling I might be wrong, but I've got a feeling that you're only allowed to take what is on original products, SMPC,
Well, that would be logical, but it would be good to have chapter and verse.
We'll get it from my lord.
You're allowed, again, you go back to the point, you don't think at the moment that you're allowed to say, don't use it.
I don't want to mislead my lord. I don't have a positive rule that I can rely on. I do remember lots of argument at the interim stage about these kinds of issues. It's not at all straightforward. And we will do that.
I was going to resume on the issue of abuse of process, and I started yesterday evening dealing with Lord Paddock's first point, which is essentially that the English law doctrine of abuse of process, insofar as it applies to amendments of patents, must be modified or misapplied in the light of Article 138 of the EPC. That's the first of his three claimed errors of law. And I think I've got about an hour on our timing. I'm going to take it quickly by taking to our written case, where we've set out MS 414, the text of Article 138, at paragraph 63, that's MS 414. As you'll see, it used to provide originally if the grounds of revocation only affect the European patent in part, revocation shall be pronounced in the form of a corresponding limitation of the said patent. If the national law so allows, the limitation may be effected in the form of an amendment to the claims, the description, and the drawings. And then we have the amendment made with effect from the 13th of December 2007, which we've set out at paragraph 65. And the amendment was essentially the introduction of Article 1383. So it said, in proceedings before the competent court or authority relating to the validity of European patent, the proprietor of the patent shall have the right to limit the patent by amending the claims. The patent as limited shall form the basis for the proceedings. Now, essentially, Lord Panic's submission yesterday was that across the law of the member states, those parties to the EPC, this was a real change because it turned Article 138 into a right to amend a patent. And at one stage, Lord Panic suggested that it was in fact a right to amend in whatever circumstances. But I think later on, he rode back a bit and said, well, within a reasonable period of time. Now, this issue has been dealt with in the domestic courts expressly by Lord Justice Jacob. See paragraph 66 of our written case. But this is an appropriate time at which to ask the court to take up Lord Justice Floyd's judgment as regards abuse, because that's a kind of one-stop shop for all of the relevant judgments, because he cites extensively from all of the previous case law. So going to the abuse judgment in the Court of Appeal, which is MS 576, that's the only place we need to look rather than trawling through all of the previous cases. And it starts at paragraph 135. I'm going to come back to that, where Lord Justice Floyd sets out the general principles of abuse. But just dealing with the Lord Panic's first point on Article 138, one can please go to page 581, paragraph 144, that paragraph 143, and just to give the court some context, and you'll already be aware of this, there are two seminal cases concerning abuse. One case is called Nicken, and that's where the principles come from. The principles, just while we're in this judgment, are set out at page 579 in a lengthy quotation from the Nicken case. And essentially there, in the period of time before Johnson and Galwood, Lord Justice Jacob, drawing upon the older authorities, had set out certain principles to be applied when considering applications to amend. Then there was a later case known as Nokia, where the argument made by the patentee is the same argument as Lord Panic is making now. He was saying, please, if you can go back to paragraph 143 of Lord Justice Floyd's 581, there's a citation at 143 of the new provision of Article 108. And if I may pick it up at 144, the argument was that this provision drew no distinction between Nicken Type A, B, or C amendments, and thus created a right, essentially Lord Panic's submission, to make an amendment of any type, subject to cases where the patentee's conduct was really culpable or amendment would cause unjust oppression. The argument was rejected because the main purpose of Article 138 was to ensure national authorities had an amendment procedure. Prior to the amendment of the treaty, the laws of some countries did not allow patent amendment post-grant at all. Article 138 was not intended to govern national rules of procedure concerning patent amendment, still less to require national courts to conduct them in a manner which national law regarded as an abusive process. Then I won't read anything further. There's also a reference there by Lord Justice Floyd to an earlier decision of his own, sitting at first instance, where he had independently come to the same conclusion. That's the Zypher case, which is in the court's bundles. So just stopping there, what was being said by Lord Justice Jacob and essentially endorsed by Lord Justice Floyd, and also independently endorsed by Mr. Justice Arnold in this case, separately, in the abuse judgment. What they were all saying is that the amendment to Article 1383 was really directed at other member states that had no amendment procedure. What it did not touch upon is the question of the procedural rules that apply in each member state. So putting it in rather more crude terms, the EPC amendment was requiring that member states have a procedure for amendments, and we've had that procedure for many years, well before the 1977 Act. Some states didn't have that procedure. One needs to separate that question, which is quite important. One needs to separate the question of whether or not an amendment should be allowed from what is logically a prior question, which is the application to amend at a particular stage an abusive process? And that's why, when the application was made to amend, Mr. Justice Arnold essentially directed the trial of an issue, which is, before I consider on the merits whether or not you should be able to amend, this looks like it may be an abusive process because we've already had a trial and a final judgment. That's a separate question, and logically an anterior question to whether or not there is, on the merits, a good case for an amendment.
Were we shown any continental case where after a trial, as opposed to after a preliminary decision by the European Patent Office or something of that nature, but after a full-blown trial, or after an appeal, an amendment was permitted? I know there are said to be differences in the nature of appeals in different jurisdictions, which may also be relevant, but were we shown...
I'm glad that my Lord raised that point, because Lord Justice Jacob, and we'll find the paragraphs either in Nokia or Nicken, says there is no case in any EPC jurisdiction where after a final trial someone has been allowed to say the loser's been allowed to amend. But I'm not aware, and no doubt Lord Panic will identify such a case. What he can show are cases in some civil law systems where the difference between first instance and appeal stages is much more fluid. So one sees in certain jurisdictions, and this is what my Lord Mance may have in mind, there is an observation by Lord Justice Jacob, and indeed in the first instance decision here by Mr. Justice Arnold, that one has to take care when looking at, say, French, German, Dutch, or other decisions, because they have points being taken on appeal, including amendments, which to a common law system look very, very odd. So one has to take care in that situation.
Many civil law jurisdictions, the appeal is a complete rehearing. Theoretically, it's that in England, but in practice, as we all know, it is not. Indeed.
And I think someone will identify for me, there's a particular passage that I have in mind where Lord Justice Jacob makes exactly that point. And just while we're on this issue, if one goes to the judgment of Mr. Justice Arnold in relation to abuse, and that judgment begins
Page?
in the MS, the judgment in relation to abuse itself is at 892, which is a separate judgment. Just to pick up the point in relation, first of all, to Article 138, if one goes to 897, paragraph 15, you have the submission being set out again. It's certainly the submission that Panic now makes. Paragraph 16 at MS 898. And he not only endorses what Lord Justice Jacob says, but he also actually says that that's his own view. Because he says in the second line, the first is that the purpose of this provision was simply to ensure that all EPC contracting states allowed post-grant amendment. And that the United Kingdom already, in fact, provided for that. But just picking up my Lord Mance's point about what happens in other jurisdictions, what we see at the bottom of page 898, MS 898 at paragraph 22, under the italicized heading Foreign Cases, we have reference to two cases there that were that relied on in particular. One a Dutch case, and one a case from France, from the Bordeaux Court of Appeal. And what's said at paragraphs 23 to 25 essentially seeks to reflect in better language than I have used the difference between civil law systems, the different procedural philosophies, and that which applies within English law. That strongly supports the submission that one has to proceed with caution when one is looking at, for example, an appeal case from France where someone appears to have been allowed to make an amendment. Now, that's the position under English law, what one calls the Nicken principles and the answer in Article 138. But as I indicated yesterday, after Mr. Justice Arnold's judgment and after the Court of Appeal's judgment, there was an instructive decision of the highest court in the Netherlands on exactly this issue, and there is an uncanny resemblance between the main submission made in that case and the submission that's been made by Lord Panic before this court, and that's the case of High Point, and it's in Divider 12.
Bundle 12, isn't it?
I'm sorry, Bundle 12.
142.
And there are two parts to this. It's at 141 and 142. And at 141, the MS number is 5532.
Yeah.
That's the opinion of the Advocate General, Mr. Wesseling Van Gent. And then there is separately from that the judgment of the court itself in the next tab at 142. Now, I'm going to just identify, in the time I've got, I'm going to identify the main points, but I would respectfully suggest that both of the judgments be read in full. In particular, the Advocate General's opinion is important because he looks at the travaux préparatoires which relate to Article 138, and the ultimate conclusion, if I summarise it before coming to the particular parts of the opinion and judgment I would draw your specific attention to. The ultimate conclusion is, number one, like Lord Justice Jacob, the conclusion independently reached, I emphasise, independently reached, is that the purpose of the amendment and the introduction of Article 1383 was really to cater for those states that provided no amendment procedure. That's point number one. And point number two, which is more relevant to this case, which is that there is nothing in the Convention, and specifically Article 138, that seeks to interfere with the procedural rules which different contracting states might seek to apply in proceedings. And we know, just stopping there for a moment, that the abuse of process rules are essentially UK procedural rules concerned with preventing abusive and duplicative litigation. And again, without taking time, I just want to give you a cross-reference to the judgment of my Lord Sumption in the Virgin Atlantic case, where there was a detailed consideration of abuse of process and res judicata. References MS 5314, paragraph 25 of Lord Sumption's judgment. And I'm just going to quote from G without asking you to turn it up. After reviewing Henderson and Henderson, Johnson and Gore Wood, my Lord Sumption explained at G, res judicata and abuse of process are juridically very different. Res judicata is a rule of substantive law, while abuse of process is a concept which informs the exercise of the court's procedural powers. I emphasise that point. It's essentially a procedural based rule. In my view, they are distinct, although overlapping legal principles with a common underlying purpose of limiting abusive and duplicative litigation. So we know, if one asks the question, what is the juristic nature of the abuse of process rule in English law, it is essentially a procedural rule aimed at limiting abusive or duplicative litigation. And we know, when we look at the High Point case, that they had a rule within Dutch appeal proceedings known as the two-statement rule. And I'm going to come and show you a particular passage. So when you appealed to the Court of Appeal in the Netherlands, they had a rule where you had one statement of appeal and one statement of defence. That was known as a two-statement rule, and it appears in the Dutch Civil Code. And what happened in the High Point case was that High Point enjoyed a patent in their mobile telephony area. The defendant was a mobile network operator, that's KPN. KPN brought proceedings to invalidate the patent before the district court. The district court invalidated the patent. High Point went to the Court of Appeal. It put in its original first statement. KPN put in their defence, so two statements are in. And at that point in time, High Point says, hold on, I want to now amend my patent. And I'd ask the court to bear in mind, this is a long, long way before the appeal is heard. It's not a last-minute amendment. It's a long way before the appeal is heard. And so the issue that arises, and now we can please pick up the judgment of the Supreme Court itself, the issue that arises, and this is at page tab 142, MS 5562, where the Supreme Court's judgment begins. The issue arises as to whether or not that strict rule, which may seem to some rather harsh, whether or not that rule was consistent with a right to amend patents based upon Article 1383. Now, just translating that to the lingua franca of this case, it's very similar to Lord Panic's argument, which is, okay, we had a final judgment. I now have a right under Article 1383. Whatever your procedural rules may be, I have a right under Article 1383, essentially to a disapplication of your local procedural rules. So in that case, they wanted a disapplication of the two-statement rule. In our case, Lord Panic asks for, and this is what's in their notice of appeal and original case, they essentially submit you can't apply abuse of process at all.
Well, I don't think that's right. Surely what they're submitting is that it isn't an abuse of process, that the principles which ought to be applied in such cases are completely different. And the Dutch case seems to me to illustrate one of the problems, it's the point made by Lord Justice Jacob that you just referred to, about drawing analogies with systems which have completely different procedural rules. The question in this case is what ought to be the procedural rule in England?
Indeed, and I suppose that maybe I'm trying to take too much out of this case. All I want to take out of this case is perhaps a modest point, which is, as Lord Justice Jacob has said, the Convention does not seek to tread on the toes of member states in relation to procedural rules. And that's essentially the ratio of the Dutch Supreme Court decision. Just picking it up at page MS 5563, under paragraph 3, points of departure in cassation. And if I can go down to the bottom of the page at 3.22, about 5 lines down, it says, after KPN in its defence on appeal, in other words, this is the second statement, refuted the grounds of appeal in the principal appeal and lodged a cross appeal, and High Point refuted the grounds of appeal in the cross appeal. High Point, in a motion to limit patent claims, amend the claim and file additional exhibits, amended its claim in the infringement proceedings. So after these procedural steps have been undertaken, it wants to make an amendment. And then one sees at 3.23 at MS 5564 I'm not going to read this out in the interest of time, but what one sees italicized there, that's essentially the Supreme Court quoting what the Court of Appeal had said in their judgment. And if I could, going over the page at 5565 and 2.4, please. If I can pick it up at the fourth line, at 2.4, as held above, the introduction of new facts and assertions is inadmissible in principle because these could give cause for a new debate. The latter applies to the new patent claims concerned in part precisely because the new patent claims may have a more limited scope and are therefore further removed in High Point's opinion from the prior art. And then carrying on, if I can skip over 2.5 and go to 2.6, the fact that High Point submitted the new patent claims apply amply prior to, there's maybe something wrong with the translation there, amply prior to the oral arguments cannot lead to any other outcome either. Whether the other party has sufficient time to defend itself against new facts or assertions is not decisive of the application of the two-statement rule. That rule is intended, as held above, to concentrate the debate and efficiently adjudicate the dispute, and therefore protects a party from having to respond to new assertions and facts, even if it's had the time to adjust its defence. So they're saying it's not just about having enough time. And then at 2.9 at 5566, we go to Article 1383. Article 1383 of the European Patent Convention does not oppose refusal of the new patent claims in this case either. That article provides that in proceedings on the validity of the European patent, the proprietor has the right to limit the patent by amending the claims. The right to amend, however, does not obstruct rules of procedure that are intended to concentrate the debate and to officially adjudicate the dispute, like the two-statement rule. Nor can High Point maintain that that application of that two-statement rule makes its right to amend illusory. I think illusionary is said that, after all, High Point was able to exercise its right to amend in these proceedings, both at first instance and on appeal. And what is more, it actually exercised that right by submitting 3 auxiliary requests. Just stopping there, again, going to this case, Warner-Lambert had the right and ability, in this case, before the trial, before Mr. Justice Arnold, to make amendments. Then just to complete this, if one can go over the page, 5567, I won't read it again in the interest of time. What they do at 4.14 and 4.15 is they look at applying the Vienna Convention. They look at other means of interpretation, and one sees a more detailed consideration of this in the Advocate General's opinion. But the conclusion is, following a consideration or observance of the provisions of Article 32 of the Vienna Convention, please see the conclusion of 4.1.5. The wording of 1383 EPC does not indicate that the right allocated therein to the patent proprietor to limit the patent in national proceedings on the validity of European patent may not be subject to procedural requirements under national law. And then 4.1.6, as evidenced by the history of the development of Article 1383 presented in the opinion of the Advocate General, and I'm not going to go to that, you have that in the previous tab, the introduction of this provision was with the aim to expressly lay down in the EPC that a patent holder in national proceedings on the validity of a European patent is entitled to limit that patent because in some contracting states this right had not sufficiently been guaranteed until then. It does not appear from the history of the development of Article 1383 that it was aimed at further harmonisation of the procedural law of the contracting states on the issue of the procedural requirements to which the right to limiting the patent is subject. And as I've indicated, one sees a more detailed consideration in the opinion of the Advocate General, but just so that you have it, I'll just identify it for you now. Page MS 5548 in the opinion of the Advocate General at 4.24, after having set out the position in Germany, and then also the position in the United Kingdom, and the position in the United Kingdom he takes at 4.24 all the way down to 4.26 from essentially the decisions in this jurisdiction in Nokia, and also the decision of the Court of Appeal and Mr. Justice Arnold in the present case. And then he reaches a preliminary...
I think it's just actually Mr. Justice Arnold,
That's right.
although called Lord Justice Arnold.
That's an error there. Yeah. Then what's relevant, I won't read it out, is the preliminary conclusion at 4.28.
Well, I think we've probably got the message.
Indeed, that's it. I'm not going to take any more time over that. So just stopping there now for the moment, we respectfully ask the court to endorse the approach of Lord Justice Jacob in Nikon and Nokia, in particular in Nokia, that Article 1383 isn't relevant. I'm going to then turn to the second issue, which is, I should have just, I'm grateful to my friend, I need to give you a reference to what Lord Justice Jacob said in Nokia about what happens in other EPO states. It's in the Nokia case, MS 5006, paragraph 137. This is what, responding to what my Lord Mance put to me earlier, I'll just quote it very, very quickly. Secondly,
Sorry,
no other
give me a
courts...
page number again.
I'm so sorry. 5006.
Thank you.
Paragraph 137. And he there says, no other courts in Europe, or indeed the EPO, emphasise that, allow a patentee who has had his patent found invalid only then in the same court to propose a limitation of it. And then he goes on to say that you've got to be careful when looking at appeal decisions in other jurisdictions. Which are much more akin, through our eyes, to fresh first instance hearings. And before leaving this point, I should just address one particular issue, which is that Lord Panic showed you a very small part of the EPC procedures. He said, and I without doing a disservice to him and putting it more crudely than he did, look at Rule 116 of the EPO, opposition division procedures. We seem to have the right there, to a preliminary opinion, and after a preliminary opinion, to make an amendment application. But again, in the interest of time, if I could ask the court to please look at our written case at page MS 423, between paragraphs 91 and 94, we've set out a summary of what happens both in the opposition division, which is essentially an administrative process rather than a judicial process, and more relevantly, the boards of appeal, which is more like a judicial process in our terms. And if I could ask the court just to look at how we introduced that summary at MS 423, paragraph 91. Unsurprisingly, the procedures of the EPO also impose certain strict procedural rules on the making of amendments in the context of EPO opposition proceedings. One can see in these procedures, as summarised below, the existence of discretion in the opposition division and on appeal in the boards of appeal to disallow late amendments and control abuses of procedure. The emphasis is on procedural economy and fairness to the parties. A patentee cannot play fast and loose with procedure and make late amendments at will. Now, I note, and no doubt Lord Panic will tell me in reply if we are wrong, there's been no suggestion on his side of the court that the summary we've given between 91 and 94, which is essentially taken from what's called the White Book, which is the summary of the case law of the boards of appeal, that's inaccurate or wrong. But the very strong message that one gets from that, particularly from the decisions of the Board of Appeal, is that if you make a late amendment application, you're regarded as abusing procedure, particularly because people should be enabled to concentrate on the originally pleaded or identified case rather than cases which are introduced at a late stage. Therefore, one sees a very similar doctrine to the doctrine one sees applying in common law jurisdictions, which is if you're late, it may well be abusive to make applications. So I don't want this court to go away with the impression that somehow the United Kingdom is out of step with other member states. No, it's not. See the Dutch case. And it's certainly not out of step with procedures in the EPO, because they're pretty strict. You can't play fast and loose. That's what I want.
I wonder how useful it is to be taken through the authorities of this country. I mean, it's perfectly clear that there is an established practice in this country that you cannot normally make an amendment application at the stage that Warner-Lambert did. The real question we have to decide is whether, in principle, that practice is justified.
Indeed.
And I think that may have to be tackled at a fundamental level of principle. You have to assume a partially valid patent. The effect of not being able to amend is that a genuinely inventive process receives no reward at all, simply because the patent is too wide. Now, I understand all the reasons why that should be so, but why is it capable of being corrected at an early stage but not at a later stage if the only difference is 2 days of hearing and the incurring of costs associated with that, which can be awarded against the patentee?
Because that principle, the idea that you can cure things by simply requiring a payment of costs is completely out of step with the modern line in English civil procedure.
Well,
so
that's going back to that's undoubtedly the position that the Court of Appeal has arrived at. But is it the right answer?
Well,
in principle?
we'd respectfully say it's the right answer, essentially for a reason, again, which this precise submission has been made to Lord Justice Jacob, and it's put in these terms, which is that I've got a potentially very valuable right, which I'm going to lose because of the procedural rule. Isn't it grossly unfair, even though I could have raised the point earlier, isn't it grossly unfair because I'm going to lose this valuable property right? And Lord Justice Jacob, in a passage which someone will remind me of, says, well, essentially that's no different to what one might say, for example, in a contract case. I might have a very large amount of money which I'm going to lose based upon the fact that I can't make an amendment at a particular stage in time. And what's the essential difference? It's just another form of property, essentially. And many things happen in litigation. Which lead to the end result that one might say, well, if it had been argued differently, or if an amendment had been made earlier, there may have been a different result. Our submission is nothing essentially different about patents in that regard. Particularly, my lord, because there is a balance that's already achieved in English law, because we'll look at this when we come to the third part of Lord Panic's submissions on whether or not it's disproportionate, because there is no doubt on the facts of this case. There was no doubt the appreciation and the ability on the part of the patentee to amend at an earlier stage. That's why I say, and this is more relevant to proportionality, it's a very fact-specific exercise. So there might be another case, it's not this case, there might be another case where out of the blue, or at a very late stage which no one has noticed, a point arises which leads to the patent being held invalid. One can see in that kind of fact case there might be a different conclusion reached. But on the facts of this case, it was actually very, very easy. Can I then turn to the second point, which is section 63, which relates to my Lord Sumption's point about partially valid, because Lord Panic seeks to rely upon section 63, but with respect to him, we don't follow how it helps him in this case. And I would ask the court to focus on the particular terms of section 63, which is 6950, MS 6950, and it's volume 17. And just by way of historical background to this section, it's important to indicate why it exists. And it's volume 17, 7950. The reason that this exists, and this is dealt with in the written case, is that prior to certain amendments, earlier in the 20th century, if one of your claims in a patent was held invalid, you lost the whole thing, the whole patent. So the origin of Section 63 and its predecessor sections was to prevent that harsh result. And that was the original purpose of it. So again, that has no application to this case, or that general principle, because there are certain claims we know that have been held to be valid, not claims 1 and 3, which are what we're interested in here. But if one looks at the text of Section 63.1, I'm going to take the court through it and explain why we find Lord Paddock's submission hard to follow. So it says, if the validity of a patent is put in issue in proceedings for infringement of the patent, and it is found that the patent is only partially valid, the court or controller may, subject to subsection 2 below, grant relief in respect of that part of the patent which is found to be valid and infringed. Emphasise that, and infringed. Now, how does this section help Lord Paddock in this case? It's a puzzle. First, the first point is, which part of his patent, or he's probably saying a sub-part of Claim 3, because I suspect he is saying that within Claim 3, I've had a partial success as regards some aspect of it. Which part of his patent, as regards Claim 3, has been found to be valid? No part has been found to be valid. What's happened is that he has accepted that he needs to amend. He needs to amend, and he has accepted he will have to show at a further trial that the part of Claim 3 that he wants to save is valid. And that's why it's quite important, in response to my Lord's questions about estoppel, it's quite important that Paddock said, and with respect to say he was right to say it, they said that we're not contending that there's any estoppel. So he can't show to this court now that any part of Claim 3 is valid, because there's going to have to be a trial on that. He accepts that. Secondly, he cannot show not only that there's no part that's valid or partially valid, but he can't show anything that's been infringed. So it's a real puzzle what he's trying to get out of Section 63. All he can say is that in other cases, where you have a patent which has a single claim, and limb A and limb B severable, and limb A fails and limb B succeeds, and they are essentially two separate inventions, in that type of case, if the court has held limb B is valid, then you might be able to get relief. But that's a million miles away from this case. He hasn't established any validity on Claim 3. He wants a new trial for that. That's why the estoppel point is very important. So with respect to him, Section 63 takes the debate no further. I'd also emphasise the point, my Lords, which this is not just a forensic point, which is that this is a completely new point. One looks in vain at the judgments of Mr. Justice Arnold and at the judgment of Lord Justice Floyd for any discussion of this argument. It's just come out of nowhere. So it's, with respect, quite difficult to see where he is going with Section 63 because he has neither a valid patent nor an infringed patent. I'm going to deal then with the third point, which will take a little more time, which is what Lord Paddock broadly calls the disproportionate result in this case. And it may be in part what my Lord Sumption had in mind, which is it not a disproportionate result? And the point I'm going to make is that whether or not it's a disproportionate result is highly fact-specific. And the correct approach to deciding whether or not there is an abusive process has been set out by Lord Justice Floyd based upon the Aldi case. So this is the essential test one is operating on appeal. And if I can ask my Lord to go to Lord Justice Floyd's judgment at MS 589, please. And if one looks at his conclusion at paragraph 183, so having set out the facts and the arguments, he says at 183, I therefore do not consider that there is any basis for this court to interfere with the judge's evaluation on the issue of abuse of process, but that is reflecting what the role of the appellate court is. And the role of the appellate court is set out a few pages earlier, and that's also with respect to the role of this court. If one goes to page 582, paragraph 147, MS 582 147, at paragraph 147, Lord Justice Floyd observes as follows. The power to dismiss or strike out an action as an abuse of process is only discretionary in a limited sense. The first task is to determine whether the conduct complained of is or is not an abuse. If it is an abuse, it would only be in rare circumstances that the claim would not be struck out. The decision as to whether the conduct complained of is an abuse is one which involves the evaluation of a number of factors, and an appellate court will be reluctant to interfere where the decision rests upon such an exercise. It will generally only interfere where the judge has taken into account immaterial factors, omitted to take account of material factors, erred in principle, or come to a conclusion that is impermissible or not open to him. And just reading 147 together with 183, what Lord Justice Floyd is there saying, look at the guidance given in Lord Justice Thomas's judgment in Aldi stores. It's not a review of a discretion, but essentially you've got to approach the judge's decision, subject to any errors of principle, with some deference. That also emphasises a further point, my Lord, which is that this issue is highly fact-specific, and therefore the question for this court under this third head of whether or not there's a disproportionate outcome depends on the particular facts. And the facts are crucial, and if I could again, in the interest of speed, take you to our written case at MS 434, paragraph 116, we hope we have fairly summarised, based both on Mr. Justice Arnold's summary of the facts, that's the procedure prior to the application to amend, and what had been added by the Court of Appeal, the essential procedural history. And again, if my learned friends want to correct that, I'm quite happy to listen to what they say, but I don't understand it to be in dispute. 116 to 117. So MS 434 to 438. And a couple of features are very important here. The first feature is that the distinction between central and peripheral neuropathic pain was a distinction that Warner-Lambert were well aware of from a very early stage. See paragraph Roman 1 on 116 MS 434, because on the basis of their patent, they obtained a separate marketing authorization for central and a separate one for peripheral. Therefore, that distinction was always apparent to them. But then as one goes through the history, it's absolutely clear, we submit, and at an earlier stage, but at the very latest, by the time of the start of the trial, a week before the start of the trial, one goes to page 437, Roman 12. They're not in dispute that a week before the start of the trial, the distinction between peripheral and central neuropathic pain and why it mattered had been firmly put on the table by Mylan and Actavis. And there was no complaint that I am taken by surprise, or I can't deal with this, or I need an adjournment. And in fact, one would say that Lord Justice Floyd and indeed Mr. Justice Arnold may have been being quite kind to Warner-Lambert, because if one looks at the procedural history, the indications are they were probably aware of it much earlier, or should have been aware of it much earlier. So we have a position where this is a point of which they are aware. On their own evidence, they were aware of it at the start of the trial. And as Justice Floyd says, and indeed Mr. Justice Arnold say, it's a commonplace that fallback positions appear in patent litigation. And the reason that it's become common is that under the current law, unlike the historic law, you lose nothing by making an amendment application, because you can make it on a conditional basis, which is you don't have to elect to give up your old claim, as used to once be the case. You can now say, I still firmly defend the validity of Claim 3, but if I'm wrong on that, and ultimately there is a conclusion that part of Claim 3 is invalid, I'm going to save it by making a conditional amendment application. And it's a commonplace in patent litigation that happens.
What was your actual pleaded case if you turned up with this point only in your skeleton argument just before trial? What was the pleaded case?
Well, the pleaded case was a general one in relation to invalidity, but what's quite important is that it became clear, certainly a few months before trial, see Roman, page 436, Roman 9.
The distinction between neuropathic, yes.
That it was appearing. Now, it's
So
quite...
it was a plausibility attack, primarily.
Indeed.
Yeah.
Well, and it's quite... My Lord's point, with respect, is a fair one. And if it had been said by Mr. Mitchison, who I think was appearing for Warner-Lambert at that stage, in this part of the case, when the point appeared in the skeleton arguments for Mylan and activists, hold on a minute, I had no idea that you were going to be running this case. You know, there may well have been an argument, but that's not their case. It's not their case that they're taken by surprise. Their case is, in all the circumstances, let us have an indulgence. So that's why I emphasise the point, my Lord, that this is a very fact-specific exercise.
And when was Dr. Scadding cross-examined, as you say, at the foot of MS 437?
I'll find the reference to that date. So it's at... someone behind me will give me the date of the cross-examination.
Yeah.
Okay. Someone will find me the date of the cross-examination. But just answering my Lord Mance's earlier point, you will appreciate from Mr. Speck's submissions that the reason that this peripheral and neuropathic pain distinction has appeared is because the way that the appellants defended the attack on validity, on claim,
this distinction
between central and peripheral appeared, because the way they decided to defend the attack on validity was by raising the point of central sensitization. So they raised it, and we responded to that and said, hold on a minute, central sensitization is not going to help you, certainly not as far as central is concerned. But to be fair to our friends, they are not saying, and they have never said, that they were taken by surprise by this point at the start of the trial. And going back to my Lord's point, Dr. Scadding was cross-examined on this issue on the 1st of July 2015.
sorry, 1st of July, yeah.
1st of July. So again, some months before.
When did Warner-Lambert first raise the question of a narrow construction of Claim 3? Do you recall that?
I believe it's in the closing submissions made. So Mr. Justice Arnold identifies, and someone finally will identify the person, he identifies that he had noticed that in Mr. Mitchison's cross-examination of Dr. Scadding, there seemed to be a different approach being taken. And he concluded that the cross-examination suggested they were going to be arguing for the narrow construction.
Wait, he says, I mean, you set it out at the foot of your...
Yes.
MS 437, Topper 438.
But I
The
believe,
cross-examination demonstrated
Indeed.
that Warner-Lambert appreciated they now had a problem, and the way they sought to address it was the narrow construction.
that's right, and I believe, going back to my Lord's point, I believe that the first time that it's actually articulated is in their closing skeleton argument
That's
trial.
what I wish to know, yes.
Yeah.
And I think we'll find the date of that.
So they were aware of a problem. They chose to use construction as the way out of the problem.
Absolutely.
Rather than conditional amendment.
Indeed, indeed.
Yes, I see.
Absolutely. And indeed, that's the point that Lord Justice Floyd made, which is they took a tactical decision, and I'm not in any way criticising that decision. They took a tactical decision, which is that there's a problem here. We've got to deal with it. We've got to deal with it. And if I could ask the court to please turn up page 588.
Yes, you're looking at the clock.
I've got 7 minutes left on my allotted time. And I'm really coming towards the end.
Right.
588, page.
Different calculations. So
How long does the law?
is everyone? Are we all right?
I certainly checked with two of my learned friends, and they said my drop dead time was 11:10.
Yes.
And I've lost a bit because Mr. Speck's taken that, but that's our side, so we're responsible for that.
Right. Well, finished by 10 past. Yeah.
I will. So 588, going to my Lord's point in relation to the way they're going to deal with it is construction. Paragraph 177, I won't read that out, but there, Lord Justice Floyd sets out that the way they decided to deal with the problem was not to say it's too late, you can't run this argument, but they were going to try the construction argument rather than an abuse.
Right.
Now,
Rather than
amendment. Now, the last point I want to make is that this again comes to the question of proportionality. Mr. Justice Arnold applied the conventional approach one sees in the Nicken principles, which is there going to be another trial necessary? Are the defendants going to be vexed twice? And he said, clearly there's going to be another trial necessary, and I believe now that Lord Panic accepts, it doesn't matter how long it's going to be, he accepts there's going to have to be another trial. In another case, which is not this case, it may have been easy where one can say, well, I've got these findings, I'm going to rely upon those findings, and there doesn't need to be any further argument. But there are going to be 3 further substantial issues argued at the trial, if there was to be a trial.
Yes.
First of all, there's the question of the clarity of the amendment. Secondly, there's a question of whether or not the amendment raises an added matter problem. And thirdly, there's going to be another argument, which Lord Panic accepts there will have to be, on the whole question of sufficiency. Because the amendment that they want to make requires an investigation at trial. None of that is in dispute. And that third aspect, the sufficiency, is going to require expert evidence again. So it's not as if one can just look at the transcripts of the previous hearing and say, well, I can essentially give a summary decision based upon what happened previously.
Just help me on the added matter.
So essentially, and I'm putting it this in a very simple way, when one seeks to amend a patent, the nature of the amendment, in other words, essentially the language and content, must be something that one can find in the original.
Well, I would have thought that they say relatively easy. You drew the distinction between peripheral and central, and
no. Well, I think the wording they want to add, by way of amendment to the patent, is wording which is going to require some examination by way of a comparison to the wording in the original specification.
And sufficiency, why is that a problem?
Because, and again, Mr. Justice Arnold dealt with this at much more length than the Court of Appeal, because the particular wording they want to add in will require a new trial as to whether or not this particular wording, which is meant to be their concept of peripheral neuropathic pain, whether or not, in fact, all of the conditions that flow from that wording will have a central sensitization aspect.
Yes, that's the issue that is already the subject of your cross-appeal.
Indeed. Well, not quite, because, again, I'm not going to go to Mr. Justice Arnold's judgment again, but he identifies that in the abuse judgment, there are examples on a very cursory basis that one can identify of conditions which would fall within, which would fall within the amended claim, but where there is no, which conditions the appellants would call peripheral neuropathic pain, but there is no central sensitization in those.
Do you have a cross-reference, the paragraphs of Mr. Justice Arnold?
I do.
I don't need to go to them, just for my note.
Certainly. So it's
Paragraph 351, isn't it?
Sorry, I know your time is limited.
Yes.
I can have it later. Don't take time over it.
it's essentially yes, I can do it right. It's MS 917, paragraphs 125
Thank you.
and 130.
Thank you.
Right.
So there need to be some further expert evidence. One final point, which is that Mr. Justice Arnold applied the conventional approach to whether or not there's going to have to be a new trial, whether or not the respondents are being vexed twice. Lord Justice Floyd took a much more modern approach, and his approach was, we say, actually in accord with the latest case law in 3 cognate areas. The 3 cognate areas, and I'll just identify for you what I say is the modern approach, that
Case management and this.
essentially a form of case management approach. So in the 3 cognate areas I refer to, we deal with these in our case at some length. There are 3 areas: late amendments at first instance, new points on appeal, and new arguments after judgment. And outside the patent field, there is a strong body of case law which now says that you do not, when you're dealing with things which are that late, the question is not can you compensate the opposing party in costs. There are much wider case management issues at stake. That's the first new modern point. And secondly, and this is essentially Lord Justice Floyd's point based upon the decision of Lady Justice Arden in the Crane case. I just need to identify the reference to that.
178.
That's right. And there, that's a question of new points being taken on appeal.
178, did you say?
Sorry, it's
That's where he refers to Crane. Paragraph 178, it's page 588.
588. That's right, my lord. So it's paragraph 178, and this is an approach which is much less favourable to someone in Warner's position than the approach Mr. Justice Arnold took. And that the approach is essentially that you don't speculate. If it's possible that something different would have to happen at the further appeal or the trial, then that's unfairness enough. We say that approach, which applies generally across civil litigation, there is no reason why that approach should not also inform the approach to amendments in patent cases. So I've gone 2 minutes over. Those are our submissions, Lords.
Thank you. Yes. Silverleaf.
On behalf of the Secretary of State,
Keep your voice up.
I have 4 basic headings which arise from the submissions which have been made to you by the parties. The first is the impact on incentivization of research by reason of the availability of patents, which is raised by Warner-Lambert as a reason for giving the broader scope to infringement that they suggest. The second is the role of generic prescribing in medical practice and its impact on the way these claims will operate in the marketplace. The third is the patent bargain between the patentee and the state and the impact of that on the scope of claims. And finally, the I will deal with our approach as explained in our printed case and the objections which have been taken to it. So I'll have to deal with each of them with a pretty light touch because I've been told I've got an hour and a quarter. Now, as to patent incentivization, it appears to be suggested that the decision in this case will have an impact on the future conduct of research into second medical uses of known compounds. If not given adequate protection, potential patentees will not be given sufficient incentive to research into such matters. However, that in our submission is not so. Swiss form claims are a matter of history. No one currently researching or in the future will be granted one. Nothing that industry does now will be impacted by the conclusion your lordships reach in this case as to the proper scope of such claims. And can I just take you to the replacement, because the replacement is important. As we and others in their printed cases have explained, Swiss form claims have been replaced by product for purpose claims, which are now the only claims allowed following the passing of the amendments to EPC and EPC 2000 and the decision in G208. Such claims solve the problems of infringement presented by Swiss claims by allowing the requisite intention to be attached to the product at any stage in the supply chain. It therefore becomes an infringing act to deal in the product for the patented purpose at any stage in the supply chain, whatever the intention of the original manufacturer. Thus, generic manufacturers are free to make a skinny label product, which indicates their intention, and it is for the subsequent dealers in the product in the supply chain, such as the pharmacists, to ensure they do not dispose of that product for the protected use. If they do, they infringe. Now, it is clear from the European Patent Office jurisprudence that this change and its effect is fully understood and recognised. And we can see that from the decision in the University of Texas case, which is in Authorities 15, tab 171 at MS 6312. This is a case where the patentee already had a patent with a Swiss form claim relating to the patented material and was seeking a further patent with an EPC 2000 claim. So the issue before the TBA was the question whether the two claims were of the same scope, because if they were, then there is an objection on the ground of double patenting. You are only allowed to have one claim for a particular invention. If the scope of the Swiss form claim and that of the EPC 2000 claim, the objection was sound, but not if their scopes were different. The TBA set out the issue. Can I pick it up at MS 6317, 18 reasons for decision? And the TBA explained that the sole reason for the objection, prohibition on double patenting, directed towards the two claims, substance of composition and the Swiss type claim directed towards the therapeutic use, were directed towards the same subject matter in the sense that both these claims concern the same invention in a different format. They then, at paragraphs 2 to 4, explain the history, established practice under the 1973 version of the EPC that a patent related to a further medical application could only be granted for a claim directed to the use of a substance for the manufacture of a medicament. They set out the authority for that, which filled the gap in the legal provisions and extended the notional novelty provided for in Article 54.5 for the first medical use to further medical use. The law itself did not contain any notional acknowledgement of novelty of a claim directed to a further medical use. Provisions of Article 54.5 fill this gap in the former provisions. Article 54.5 now permits, this is the new version, purpose-restricted product protection of any substance or composition comprised in the state of the art for any specific use in a method referred to in 53C. And the reference there is to G208, which is the decision that said they are now the only form of claim you can have. And I think Lord Panic referred you to that. The major reason for the amendment to allow purpose-limited product claims, further medical use claims, was to create greater legal certainty in relation to the patentability of further medical use claims and to overcome doubts as to the validity of the Swiss-type claims. As pointed out by the enlarged board in G208, Swiss-type claims could be and have been considered objectionable as regards the question as to whether they fulfill the patentability requirements due to the absence of any functional relationship of the features belonging to therapy, conferring novelty and inventiveness, if any, and the claimed manufacturing process. The board then points out the examining division's refusal was based on certain guidelines. They analysed the problem in detail, turning to the subject matter and scope of protection. And can I pick it up at where they reach their conclusions at 22 on page 6321? It follows from the above analysis, see points 16 and 17, that the claims under consideration belong to different categories. That is, purpose-limited process claim versus purpose-limited product claim, and differ in addition in at least one technical feature. It is generally accepted as a principle underlying the EPC that a claim to a particular physical activity, e.g. method or process use, confers less protection than a claim to the physical entity per se. See the decision in G288. It follows that a purpose-limited process claim also confers less protection than a purpose-limited product claim. The scope of protection sought by the invention claimed pursuant to the present main request is thus noticeably different from the scope of protection conferred by the previous claims. And for that reason, the objection of double patenting was held unsound. So it is clear from that case that the Technical Board of Appeal recognised that purpose-limited product claims are broader in their scope and more certain in their application than purpose-limited process claims. And this case is concerned only with purpose-limited process claims. The court in this case, in my respectful submission, is in effect being asked to give the Swiss form claim, the purpose-limited process claim, the same scope as the EPC 2000 claim, the purpose-limited product claim. And the court should, in our submission, resist the temptation to do so on the de facto basis of an alleged problem in a particular case without reference to legal principle. The temptation should be resisted all the more when the evidence shows that the patentee in this case, as you have seen, in fact retained a very substantial market share. Now, it's also important to appreciate that even in this historical context, the problem of generic products being supplied for the patented indication and the inability to distinguish between them only arises where both the old and the new indications have the same dose and dosage form, and the skinny label and full label versions of the product are effectively identical. Because if they're not identical, you can determine the use to which the product is directed simply by looking at its form. As far as we're aware, it has not been suggested that there are large numbers of cases in which the problems in this case have arisen. And as the judge at the trial pointed out, this is the first time, these claims having been available for over 30 years, that this particular problem has been put fairly and squarely before the court.
Probably not a matter for you, but it just occurred to me to wonder why the pharmacists and pharmacist associations in their interventions have expressed such concern about the implications of this case and the Court of Appeal's approach. If firstly you're right in saying that this problem has never arisen before, or very rarely, and secondly, I think you've just told us that under the new regime, pharmacists are exposed. Is there some protection which under the new regime which means they're not really exposed, or what?
Well, they'll only be exposed if they use the generic product for the patented indication. If the product has a skinny label on it, they know what they can and can't do with it. Because
they don't know what the indication is for which the patient is being treated.
They receive a prescription from a doctor which
simply says pregabalin.
That's certainly true. But that's the particular problem that's raised by the case where the old purpose and the new purpose can't be distinguished from by the form of the product. And what I'm pointing out to you is that this is the first case in which this has happened. or in which this matter has been raised before the court. And
There have been other cases where the dosage is different.
if the dosage is different, you can see straight away what the application is, because you know from...
So my question still applies then. I mean, we can't ask them because they've put in written submissions, so are we permitted any written submissions? But
Well, they are concerned because, as I understand it, they're going to be faced with a problem they can't deal with if they infringe when they can't tell whether they're infringing. And that's their difficulty.
They're concerned with the implications of some of the more extreme versions of Warner-Lambert's case.
Now, in our printed case, you will have seen that we've said that the proper approach to this, and this must apply equally with application limited product claims, is that the patentee and also the generic manufacturer are under an obligation to inform the market of what the position is if they want the monopoly respected. And educated with knowledge, the pharmacists can deal with this. What they're concerned about is that if they don't have the information, they won't know what they can and cannot do.
Something that I don't know if you're going to deal with it at some stage, but it's not at all clear to me what the background powers are or relationships in the NHS that regulate how drugs are prescribed, for example. Why do doctors prescribe generically rather than using a brand name if there is a patented product for the particular use they have in mind? And does the NHS have any powers to direct doctors as to how they prescribe drugs?
Can I turn directly to, in answer to my Lord's question, to the role of generic prescribing? Now, we deal with this in our printed case at paragraph 36, which is core volume 2, MS 491. We point out that at the trial, on behalf of the Department of Health, Ms. Jeanette Howe gave evidence. There are 2 witness statements. They are in Appendix Part 2, starting at MS 1200. The judge summarised her evidence at paragraphs 376 and 377 of his judgment. And if I could ask you to turn up very briefly a couple of short passages from her evidence. They explain why generic prescribing is very positively encouraged, with the result that over 90% of prescriptions are written generically, and what the effect of that is. So could you go to Appendix Part 2, page 1202, I think it's the reference. This is Ms. Howe's first statement, and it's paragraphs 6 and 7 on that page. Long-established policy positions to support generic prescribing. Even if there is only one brand, prescribing generically supports prescriber understanding of the treatment and the nature of the product they are prescribing. It tends to give greater certainty amongst healthcare professionals treating a patient when, for example, patients move between care providers, e.g. on discharge from hospital, as to the patient's treatment regime. Prescribing generically also tends to remind clinicians of the therapeutic action of the drug, so they are less likely to prescribe a drug of similar action, unintentionally causing duplication, or to prescribe a second medicine which is incompatible with the first. And this is very important, because if you turn to Ms. Howe's second witness statement at paragraph 27 at MS 1219, she gives some more detail about the effect of movement between care settings. Just before I go to that, of course, one of the important things about generic prescribing is the generic names of the drugs are designed to give an indication of the nature of the drug to the practitioner. So drugs in a particular group will have common roots to their names, and the drugs are therefore identified by their medical effect in the practitioner's mind by the use of the generic name. Of course, if you use a brand name, that's not necessarily so. And brand name prescribing is well known to increase medication errors.
But the problem on the other side is that if you prescribe generically, then there's a likelihood of patent infringement unless the pharmacist asks a patient about what their problem is, which gives rise to all sorts of issues about patient confidentiality.
There is, I should be explaining to your lordships, there is no way of squaring this circle. The position that the department takes, for obvious reasons, is that clinical considerations come above everything else. Patient health is paramount, and generic prescribing is therefore important. And if you turn to MS 1219...
Well, except that they have, well, it's not the department who has, it's the NHS authorities have effectively advised, and I think its status is merely advice, but it's largely been followed, that for the patent indications in this case, the branded product ought to be prescribed. I mean, are you saying that that advice is contrary to the ordinary policy of the department?
I'm saying that advice cuts across the normal practice, and it was done at essentially the urging of Warner-Lambert and the indication by the judge that it was appropriate as a matter of effectively case management at an early stage of these proceedings in order to try and deal with the problem that was presented by this. This case has been a learning process for everybody involved.
Is the department's position that this will not necessarily happen in another comparable case?
The department's position is that the patentee and the generic manufacturer are primarily responsible for ensuring that the market, whether it's primary or secondary care, knows what the patent position is and enabling the market to deal with it. And one of the things I can tell your lordships is that as a result of what's happened in this case, in the secondary care market, the NHS has changed its procurement approach and invited patentees to indicate whether they have second medical use patents when first procuring generically when products come off patent.
And in due course, under the current law, this will go away, this particular problem.
Because of EPC 2000, yes.
Where as a matter of interest, where in the current law, which I was just looking at, is the position of pharmacists regulated? It doesn't follow, does it, from the provision that the patentability of any substance or composition for use, for a specific use, is not excluded, provided such use is not already comprised in the state of the art. I mean, that introduces the product based patent rather than a process-based patent. But where is it? You said something about the pharmacist being exposed. Where does that follow from? Because that seems to focus on. I see the patentability attaches to the product, so at each point, it's only for that use is the answer. It's as simple as that.
Yes, sorry, yes,
yes.
It's a very simple point.
Yes, no, well, I've got it now. Thank you. Yeah.
Yes. Can I just ask this? I'm looking at the long-established policy reasons for generic prescribing in paragraph 6 and 7 of Ms. Howe's witness statement. Why is an instruction to prescribe a branded product necessarily incompatible with the achievement of those policy objectives? Why can't the prescriber say Lyrica brackets pregabalin? And then everybody knows what the family from which that branded product comes, what the underlying medical name of the substance is, and yet it is a prescription which avoids the problem for the pharmacists.
That is effectively what's happened in this case.
That is what happens.
Yes.
I see. So when you said it cut across the ideal, the advice cut across the ideal. In fact, if it's complied with in that way, it doesn't really cut across the ideal at all, does it?
Pure brand prescribing cuts across it, but
yes. But if they prescribe branded with the generic name in brackets, that wouldn't, would it?
That
As long as pharmacists understand what it means.
As long as pharmacists understand what it means. And as I understand it, if you look in more detail at the evidence, you will see that, as Ms. Howe explains in her second witness statement in some detail, most of the primary care prescribing is done by GPs using particular kinds of software which have been programmed to trigger to GPs giving prescriptions the indication they should prescribe as Lyrica pregabalin for pain. Of course, now it's expired, that goes away, but now the current patent has expired, that goes away. But while this litigation was going on, that was the approach that was taken. Now, the point I really wanted to make was this case has been a learning process for everybody because it's never happened before. It may well be the case that in future circumstances, different approaches are more appropriate to deal with the problem. One simply doesn't know. And the concern that we have is that the court should not seek to prescribe a particular way of dealing with the problem when the problem may manifest itself in different circumstances and be more effectively dealt with in different ways. The important thing that the court should do is get the scope of the claim right. Can I just finally...
Well, the question of infringement and how the manufacturer avoids infringement inevitably raises questions of the kind we've been discussing about labelling and
Well, the problem arises if one takes a version of the Warner-Lambert approach or the way the Court of Appeal has dealt with it, because what they're doing, and we say this is wrong in principle, is substituting the requirement in the claim for intention, which appears to be common ground, is what a Swiss form or EPC 2000 claim means by for, and substituting for it a requirement of foreseeability in circumstances where the manufacturer can do nothing about.
Well, they're both tests of intention. What is foreseeable is intended in an objective sense. I think you're using intention in a subjective sense. You say that that's common ground. There's been a certain amount of discussion about that, and it may not be common ground between bench and bar.
Well, I've thought long and hard about whether it is correct to describe the distinction as between subjective and objective intention. My respectful submission to you is that actually it isn't. It's always an intention which the court must objectively determine. But as, my lord, you yourself said in Fish and Fish, mere knowledge that something will happen is not sufficient. What is required is other circumstances. And
That's true in the context of the economic torts.
Yes.
I'm not sure it's true generally.
This is an economic tort.
Well, by the economic torts, I'm talking about the common law torts, intentional harm, conspiracy, and so on.
Can I come back to that when I reach that point in my submissions? I just, before I forget, like to pick up the point made in paragraph 28 by Ms. Howe, because it indicates the importance...
Just remind me where she was.
Sorry, MS 1219
yes.
in Appendix Part 2. As she points out, that particularly when you have a change between care regimes, there is a high rate of error, and it is therefore important to ensure that insofar as possible, the prescribing regime is kept uniform from stage to stage, and generic prescribing is an essential element of that.
Rather alarming statistic.
It is. I think what it tells us is that medical practice is more difficult than the job we do. The policy of the law prevents patent protection for methods of medical treatment. It's important also to keep that in mind, because one can devise an amazing, inventive new treatment, new method of treatment, but no patent can be granted for it. The policy is that it is and should be free for use, and that's what one sees reflected in the EPC. Can I now turn to the patent bargain, because that is an essential part of the policy. And some care is needed when considering appeals to policy in this case because of the patent bargain. At its core, the rationale of patent protection is the state gives the patentee a 20-year monopoly, a time-limited monopoly on his invention, in return for its public disclosure and consequent dedication of the invention to the public, following the expiry of the monopoly. I'm sure your lordships don't need reminding that the basis for the statute of monopolies was that monopolies were time-limited. A key part of the rationale is that the scope of protection given to the patentee reflects the extent of the contribution that the invention makes to the state of the art when the patent is filed. And this is commonly referred to as the patent bargain. The bargain has two sides. On the positive side, the patentee receives its monopoly and market exclusivity, and it can use that to justify higher prices for its patented products and obtain a return on its investment. An important part of that is that the scope of the monopoly must reflect the technical contribution, because otherwise the patentee is getting more than he deserves.
Must reflect disclosed.
Yes. In return for that reward, the patentee must dedicate his invention to the public following expiry, so that once the period of exclusivity has ended, anyone becomes able to work the invention that was formerly protected. And that is critical in this case when we come to the place of second medical use patents. The fact that there's already been a primary patent and a 20-year monopoly is an important factor to bear in mind. This allows free and effective competition in the market following expiry of the patent monopoly. Dedication of the invention to the public requires that the public be free to exploit the invention without let or hindrance once the monopoly has expired. This is fundamental and is a principled objection to Warner-Lambert's approach to infringement, which I shall return in more detail. And it leads naturally to the point that the scope of the protection must reflect the patentee's contribution to the art. One can see this stated in many cases. It's a fundamental principle. It's very succinctly put by Lord Justice Floyd in Generics and Yedder, Authorities 2, tab 21, MS 1983. 1983.
83, thank you.
He said this in the context of obviousness because the point arises in multiple contexts: obviousness, sufficiency, scope of claim. The technical results or effects must be shared by everything. This is paragraph 39 at the top of page 1983. The technical results or effects must be shared by everything falling within the claim under attack. This follows from the fundamental principle of patent law, which underpins many of the grounds of objection to validity, that the extent of the monopoly conferred by a patent must be justified by the technical contribution to the he goes on to say that if you've got a common, some parts of the claim have a particular property, but others do not, then the technical problem cannot be formulated by reference to that property. You have to find one that is common to the whole of the claim. We see a similar statement by Lord Neuberger in the previous tab, at page 1966, Generics and Lundbeck. At paragraph 95, this, I think, was in the context of claim width insufficiency, Biogen insufficiency. Finally, Lord Hoffman emphasised that the extent of the monopoly claim should not exceed the technical contribution to the art made by the invention as described in the specification. And he then goes on to give a particular example. As already explained, in the context of a simple product claim, such as the present, especially where the claim is to a single chemical product, the technical contribution is, at least in the absence of special factors, the product itself.
But that isn't a problem in this case, is it?
No.
It doesn't. Both these paragraphs are satisfied, as a matter of fact.
I'm not
No.
sure I understand the question.
But on there, I mean, the product, its technical contribution, ex post facto, can be seen to be that which the patent claimed. But whether the patent claimed it appropriately is what we're talking about. Isn't it?
Yes, and that's because we're in the specific regime of second medical use
Right,
patents,
right.
where the contribution is not the product, but only the new use.
Yes, yes.
And that's the point I'm making is, let me make it formally. That principle, could I also just give you a further reference at Authority 6, tab 60, page 3419. One finds exactly the same statement in the Technical Board of Appeal in the Exxon case, in the final sentence of paragraph 7, I think it is.
Paragraph?
Final sentence of paragraph 7 of the Technical Board's.
Paragraph 7.
3, just let me check
Exxon.
the reference.
Didn't have a paragraph.
3419, Authorities, Volume 6.
Doesn't have
Not on this page.
Yes, it's the, sorry, that's an absolutely,
Right.
it's 3419 is the start of the case, it's 3457, the paragraph starts, the sentence is on 3458 at the end of paragraph 7. In paragraph 8.
3457.
It's paragraph 8 on page 3458, final sentence. Am I?
We've been shown
I'm
this.
sorry, I'm in salt.
We're taken to this.
I do beg your lordship's pardon. That's Salk. You will find the same thing in Exxon at tab 60. That's 341.
But if it's the same thing, doing
3419 in the final paragraph and in the headnote.
Yes, the point Lord Hoffman was making was that it had to be the contribution to the art as disclosed in the patent description.
Yes, I'm sorry. The Exxon reference is 3419. It is the last paragraph on the page. And in the middle of the paragraph, the patent monopoly should be justified by the actual technical contribution to the art. And you find that summarised in the first 3 points of the headnote on page 3413. So, this is a fundamental principle, and its consequences are important. The law, in our submission, needs to be acute to ensure that the patentee is not getting more than the monopoly to which it's entitled. In other words, that the bargain with the patentee is kept. In the case of second medical use patents, there are unique difficulties with this. And those difficulties are exacerbated by the fact that Swiss form claims are process claims and not product claims. As you've seen, the judiciary created the Swiss form claims. They've been described as a fudge. I prefer to use terminology common in the world of computing. They are a workaround. The statute didn't deal with the problem. The original EPC contains no guidance on whether it's permissible to claim the use of a compound to manufacture a medicament, so it was free to create such a class of claims to work round the deficiency in the statute. But like all workarounds, Swiss form claims are not a complete solution. They're a way of dealing with it, working round it, and they therefore have deficiencies, and in our submission, the correct response to that realisation is to accept those deficiencies. It is not the right approach to distort the meaning of a Swiss form claim so that it brings within its scope something which has been dedicated to the public and which the public should be free to work. But that is precisely what Warner-Lambert proposed. It's particularly important not to do that where the legislature has already intervened. And as I've explained, there are clear differences between the effects of product claims and the effects of process claims.
Would that be a convenient moment for a 5-minute break?
Just before I resume the thread of my submissions, I've had some rather concerned instructions from behind me. There are well-established conventions in prescribing practice, and I would urge the court not to arrive at a ruling which is going to undermine or interfere with those conventions. They are there for clarity, to try and ensure that correct clinical practice is followed. A prescription that has more than one indication, on more than one description of the product being prescribed on it, such as the brand name and the generic, is liable to lead to confusion as to what is intended. And it's therefore, what I'm really saying is, this is very fact-specific, and what we should be looking at is the principle. What the court should be addressing is the principle. How that is dealt with in practice in a particular case is something that the parties and the health service need to work out between them. The objective is to ensure that the patentee gets the appropriate scope of protection, no more and no less. But trying to find a mechanism on the hoof in court is unlikely to arrive at a satisfactory result.
So your prior statement about prescribing Lyrica versus pregabalin, we put a red line through that.
I was wrong, I'm sorry.
Okay, thank you.
I was just finishing off the point that the legislature has already intervened to deal with the recognised difficulties
we've got
of
that.
infringing purpose-limited process claims. Second, the purpose-limited product claims do not have those difficulties, as I've said. That's precisely what the TBA decided in the University of Texas case, which I've already shown you. Now, in relation to that bargain, the final we are dealing with a very particular aspect of it. The patentee has had a 20-year monopoly on the molecule itself and had its reward for its invention. That monopoly has expired, and it is essential that third parties are free to work the invention that justified the grant of that monopoly in the first place. That is the requirement that the invention be dedicated to the public. There is also, when dealing with pharmaceuticals, a clear public interest in ensuring that generic versions of drugs become available once the monopoly has expired. Purely on financial grounds, they are much cheaper. In order for that to be the case, it is crucial that once the patent has expired, the law ensures it does not linger and chill third parties who would otherwise wish to bring products to the market. Now, can I turn now to the meaning of 4 and our proposal for our approach to addressing that? It is basically common ground that 4 in a second medical use claim means for the purpose of. Warner-Lambert specifically accept that in their printed case at paragraph 290, MS page 226. The scope of the claim is to cover the use of a particular ingredient in the manufacture of product for the purpose of treating a particular disease. In our submission, such claims should not and do not cover a product which may or may not be used for the treatment of that particular disease. The issue that's arisen on infringement in this case is primarily because Warner-Lambert doesn't accept that a straightforward application of that meaning to those claims gives them an appropriate extent of protection. Those arguments are all based on the way the market for medicinal products operates in this country. And as we have emphasised in our printed case, the cure for this, if one is needed, lies not in illegitimately distorting the meaning of the claim language, but in informing and educating the market, the primary responsibility for which must lie in the hands of the patentee and the generic manufacturers as those who supply the market. Now, it is in our submission important to distinguish mere possible foresight of something that may happen from an intention that it should in a case such as this. One may well have foresight of something that is likely to happen in the future, but over which one has no control. Therefore, one cannot intend that it happen. We deal with this in our printed case by reference to Cunliffe and Goodman in paragraphs 8 and 9 at MS 484, where in Cunliffe and Goodman, Lord Justice Athworth made the point in the second paragraph, which is at the bottom of the page. X cannot, with regard to the English language, be said to intend a result which is wholly beyond the control of his will. He cannot intend that it shall be a fine day tomorrow. He can most hope or desire or pray that it will.
Well, what I think is being suggested is that it is under their control because the last analysis they can stop manufacturing. That is subject, of course, to the suggestion that an alternative would be to deliver an account of profits. But logically, if you, although you have no control over what the pharmacist does, you can deprive him of the means of doing it with anything other than the branded product.
That is true, but of course the consequence of that, my lord.
But I mean, as you say, that puts in a most extreme form the vice that you described in your last submission.
Exactly.
Yes.
And that's the problem. That my lord is absolutely right. It is the circle one cannot square in this case. And the difficulty with anything other than the kind of approach that we advocate is that it categorizes as infringing conduct which, as a matter of principle, should be lawful and unfettered. And therefore, we say it cannot be right. Now, that's why we say in these circumstances, substituting a requirement of foreseeability for determining, as a basis for determining whether an act falls within a Swiss form claim, is wrong as a matter of principle. The principled approach is to find a reasonable or appropriate way of determining the requisite purpose or intention. And just to make the contrast, Lord Panic referred to Grimm as illustrative of how foreseeing that some of your products may be used for infringing purposes should be sufficient. And of course, Grimm was a case under Section 60, subsection 2, which is a special statutory extension. And in our respectful submission, you should look at Section 60, subsection 1c and Section 60, subsection 2 independently and construe them independently. And secondly, Grimm was an extreme case on the facts. If you look at paragraphs 70 and 76 of the judgment in Grimm, the defendant was supplying the machines with an express encouragement to convert them into an infringing format, and he was supplying 60% of his spare parts supplies, whereof the components, the resilient rollers, which were suitable, which were required to convert them into an infringing format. And he had it entirely within his power to stop that. He could simply supply them in a non-infringing format, and
You can simply do what?
supply them in the non-infringing format with the solid steel rollers, and not encourage people to change them. So that was completely different. So as a matter of fact, it's different. As a matter of legal principle, it's different because Section 60, subsection 2 specifically extends, statutorily extends to cases where people have specific knowledge. And we say that to try and draw an analogy between that and direct infringement under Section 60, subsection 1c is wrong in principle. The authorities that we have cited show very clearly that direct infringement is not committed by supplying a product to someone you know is going to infringe. The Court of Appeal Authority in the Dutch case, the case that everybody calls belegging because no one can pronounce the name of the party, Authorities 13, tab 152, I'm not even going to try and pronounce the party's actual name. The background to this...
Sorry, can I have a page?
I'm sorry, it's tab 152, MS 5776 is the start of the case.
Thank you.
And just picking up at the head note, the background, the plaintiffs owned a patent for diamond grit coated with metal of a specified thickness and embedded in a rubber there was no claim to the metal-coated diamond grit per se, because that was known before the priority date. And what was being supplied was the metal-coated diamond grit. So the question was the supply of that an infringement? And if you go to 5781, Lord Justice Buckley, picking it up just below the second full paragraph, just below the halfway line, the patent creates no monopoly in metal-coated diamond grits, nor in any particular kind of them. So apart from the Patents Act 1977, to which I shall come back, and that's of course section 60, subsection 2, supply of that commodity cannot itself constitute an infringement, and he cites Townsend and Howarth and Dunlop. In the former of these two cases, Lord Justice Mellish stated the principle tersely and forcefully as follows: selling materials for the purpose of infringing a patent to a man who is going to infringe it, even though the party who sells it knows that he's going to infringe it and indemnifies him, does not by itself make the person who so sells an infringer. He must be a party with the man who so infringes and actually infringe. The other two members of the court agreed with that. There is no infringement unless there are circumstances which give rise to joint tortfeasance. You have to be a party with the other. That is not alleged here. That case is entirely consonant with this court's decision in Fish and Fish, which we cite in support in our printed case, so I'm not going to go to it. The point is that absent joint tortfeasance, infringement can only be found under section 60, subsection 2. For direct infringement, supply of means alone, even with knowledge that they will be used to infringe, is insufficient. If you then turn to tab 154,
deals with indirect infringement later at page 67 and follows.
Can I now briefly take your lordships to Amstrad, CBS and Amstrad, which is tab 154. Page 5818, your lordships may or may not be aware, this was a case about the supply of twin tape cassette decks. You can run one tape playing something and the other tape copying it. And the allegation obviously was that this was inducing infringement by copying copyright works. If you go to Lord Templeman's speech, where he discusses the case we've just looked at 5861,
I'm sorry, page?
5861. Right at the bottom, letter H, the final paragraph, he introduces Belegging and quotes what Lord Justice Buckley said. And then he describes joint infringement. Joint infringers are two or more persons who act in concert with one another pursuant to a common design in the infringement. In the present case, there was no common design. Amstrad sold a machine, and the purchaser or operator of the machine decided the purpose for which the machine should from time to time be used. The machine was capable of being used for lawful or unlawful purposes. All recording machines and many other machines are capable of being used for unlawful purposes, but manufacturers and retailers are not joint infringers if purchasers choose to break the law. Since Amstrad did not make or authorize other persons to make a record embodying a recording in which copyright subsisted, Amstrad did not entrench upon the exclusive rights granted by the Act of 1956 and not in breach of the duties imposed by the Act. He then dealt with a number of other arguments, and one little point I'd like to pick up at the back. Very last page, 5867, the final paragraph of Lord Templeman's speech, he draws attention to the unsatisfactory state of the law as a result. Since 1977, when the Whitford Committee reported, a levy on blank tapes has met with more favourable consideration. In face of the difficulties inherent in the problem generated by the mass production of electronic equipment capable of infringing copyright, Parliament has not yet determined on any course of action. These proceedings will have served a useful purpose if they remind Parliament of the grievances of the recording companies and other copyright owners, and if at the same time they draw the attention of Parliament to the fact that home copying cannot be prevented. It is widely practiced and brings the law into disrepute. As the law now stands, I would dismiss the appeal. The point I want to make is that the court there recognised that the law was in an unsatisfactory state, but that is not a reason for trying to apply a judicial elastoplast to it, the better course is to encourage the legislature to intervene. Now, in the present case, the legislature has already intervened. The court does not need that to issue that encouragement. Still less, in my respectful submission, should the court be itself induced to apply the judicial sticking plaster in order to ameliorate the problem. The problem should simply be recognised for what it is. As I've already said, fish and fish, which is at tab 157, I don't propose to take your lordships to it because we've dealt with it in full in our printed case, considered those cases and concluded that what is required to reach a finding of joint tortfeasance is common intent. Assistance, even knowing assistance, is not enough. And in our respectful submission, it would be surprising if a state of knowledge which is insufficient to found liability as a joint tortfeasor is sufficient to make a party a primary infringer of a claim which requires a specific purpose. That would be against the approach of the law generally. The requirement for intent is a control mechanism to limit the ambit of a person's obligation to safeguard the rights of others, and should be so treated here. And I would also point out that following the decision of this court in R v. Joji, the same principle applies to the criminal law. We therefore say the proper conclusion is that more is required than supply with knowledge of a likely use to give rise to the creation of the requisite intent on the part of the manufacturer. The real question is how one determines whether the intent is present. Now, we say that that matter ought to be approached practically. Clearly, if the manufacturer acknowledges or says expressly that he has the requisite intention, for example, a full width label, then that is sufficient. But in the absence of such material, one must look, as Lord Sumption said in paragraph 44 of Fish and Fish, to other matters, other circumstances. And that is what we say should happen in this case. One can look objectively at the determinable market conditions. How much of the product in question is being used for the patented purposes? How much is being used for the generic purposes? It is clear from the judgments below that there is ample information about what is happening in practice in the market. The IMS data is being used. Everyone was evaluating the proportion of the market that was attributable to prescriptions for pain as opposed to prescriptions for the other indications. The parties know this, and ultimately, when required, the court can be given that information. Using that information, one can assess whether the generic manufacturer is in truth seeking or intending to encroach upon the patented use. The only objection that we can see from either Warner-Lambert or the ABPI, who join with them on this, to that approach is that it is impractical to measure what is happening in the market. But in reality, their proposal, looking at the same problem at the stage of an inquiry as to damages or the account of profits, requires exactly the same questions to be asked and answered as the approach we take. Warner-Lambert's proposal seeks to evaluate the appropriate market share in order to determine the extent of the profits which the generic manufacturer should be required to disgorge. That's exactly the same way we say it should be approached, but at the stage of assessment of liability. We say it's wrong in principle, and I should point out it's also on the evidence clear that they are themselves doing this now because they engage in brand equalisation deals, the prices of which are determined by the extent of the market that is occupied by the patented or the non-patented use. That's paragraph 506 of the trial judgment, Mr. Justice Arnold's trial judgment, at core volume part 3, MS page 839. And you will see that those brand equalisation deals, Pfizer's original proposals for the brand equalisation deals were based on the percentage of pregabalin being prescribed for pain being 59%. This was subsequently changed to 78%. So they are using this data themselves for their own commercial purposes, why should it not be used in exactly the same way for the purpose of determining whether generic manufacturers have an intention to trespass on the protected territory?
I'm slightly. Can I raise with you a way I've been thinking about it, for your comments. If we're looking at 6160 subsection 1c. The infringement is disposing of, read short, disposing of a product obtained directly by means of the patented process. Yes. And the difficulty that faces us with Swiss form patents is that you can't tell from just looking at the tablets whether they've been obtained directly by means of the patented process or by means of a process of which the patent has expired.
Yes, because it's the same, of course.
Yes, exactly the same tablets. So, trying to answer the question, well, is a generics manufacturer disposing of a product obtained directly by means of a currently patented process? If you can't answer it by looking at the tablets, can you answer it by looking at the packaging of the tablets?
Well, that's...
If you don't look at that, how else?
That essentially is the skinny label point, because what the manufacturers are doing is putting on their labels the non-patented indications, because that is the market which they are targeting.
The packaging is part of the manufacturing process.
Yes. Yes. And
so, on the face of it, that identifies the purpose.
Yes.
Objectively.
Objectively, that identifies the purpose, and
But
one route is simply to stop there.
Objectively, but not conclusively, in the sense that someone who puts a skinny label on a package which he knows is going to be used for another purpose wouldn't be able to rely on his skinny label. If
I don't think it's enough to say he knows. I mean, you'd have to say that notwithstanding the skinny label, that one could infer objectively an intention that it was used for another purpose and was sold for that purpose.
Well, that's where I say you look at the surrounding circumstances.
Very hard to envisage facts which could give rise to that question.
I would have thought on your case they would inevitably arise, wouldn't they? On the contrary, because in reality, bearing in mind the way doctors prescribe and chemists operate, there will always be some usage. May not be huge, but there'll be always some usage contrary to the
That's
patented purpose.
Yeah, I think that's what Lord Sumption described earlier in the hearing as leakage.
Yes.
That's why we say it's wrong. You can't look at this on a packet-by-packet basis and make any sense of how these claims operate. You have to look at it on a more holistic basis, look at the market as a whole. Now, for example, if a generic manufacturer went to one of the major pharmacy chains in this country and said, I will supply 100% of your requirements for this drug, even though it had a skinny label on it, that would be a circumstance in which it would be fairly straightforward, I would suggest, for the court to infer that he had the intention that it should be used for the patented purpose.
Precisely so, yes.
What I'm saying to you is, this is not the place to try and work out what those facts might be. There will be facts and circumstances in every particular case, and they will be different in every particular case. But the reality is that if, by and large, the generic manufacturers are taking the generic proportion of the market, and the patentee is taking the patented proportion of the market, things aren't working too badly. And to try and achieve better than that by applying artificial meanings to the word for in the claim, or by laying down rules as to how the parties are to behave in the marketplace, is unlikely to improve things clinically or commercially.
But in a sense you are doing that, aren't you? Because you talking about volumes actually supplied as objective evidence of intention, and I think you then qualify that to allow for inevitable leakage, which really nobody can be blamed for, by saying that a generic manufacturer who takes reasonable steps to educate the market should not be taken to have the requisite intention to infringe. So, I mean, aren't you really introducing the sort of qualifications about reasonable steps which the Court of Appeal was attracted by? Aren't you, you're really saying that if in truth the percentage sales demonstrate that there must be leakage, and if the manufacturer hasn't taken further steps beyond the labelling to counter that, then the manufacturer should be an infringer.
We certainly didn't intend to say that.
Or should be held to have should be taken to have the requisite intention to infringe.
What we were trying to do was illustrate rather than define.
Prescribe. No, I mean, but nonetheless, we're searching for some understanding.
Your submission. You're saying that that the manufacturer is only going to be liable if he takes some positive step to, in effect, counter the impact of his skinny label, e.g. your example of going to a chain of pharmacies and saying, I will supply 100%.
No, I was giving an extreme example in order to illustrate that.
Yes, I mean, I don't see paragraph 39 that way around. It looks to me the other way around in your case.
What we are saying is that the answer to this problem, Swiss form claims are inherently difficult and cannot be fixed, if I may put it like that. The proper approach to the problem they present is therefore to take a practical approach and look for the requisite intention in the marketplace and to understand that the primary cure, if I may put it like that, is for both the patentee and the generic manufacturer to make clear to the purchasers, that is the NHS in secondary care and the pharmacies in primary care, what the appropriate uses of their products are. And if one does that, by and large, the patented product will be used for the patented use and vice versa. Now, it won't be perfect, but it's probably as good as one can get.
We're not submitting that mere leakage on whatever scale, unless possibly provoked something else that the manufacturer does, makes the manufacturer an infringer. No.
Whereas Warner-Lambert's approach does.
Well, exactly. It's the foreseeability approach that you're taking issue with.
If the manufacturer objectively has the intention of penetrating the protected patented market, then would the pharmacists and any supplier further down the chain be liable under 60 subsection 1 subsection C?
Yes.
I think it must be.
Yeah.
Yes.
So the market itself encourages the manufacturer to act in a way that reassures those further down the chain that he has done his bit.
The manufacturer is encouraged to act in a way that
But if the manufacturer wants the pharmacist to take the risk of selling his product, then he is going to have to persuade the people further down the chain that he didn't have the intention of penetrating the market.
Exactly. So the manufacturer is incentivized to behave properly.
Yes.
The pharmacist is incentivized to behave properly by the risk of infringing. And the market ought to recognize and respect these patents. And that, in our respectful submission, is the best one can do.
Yes.
And to try and do more is like to make the problem worse rather than better. And that's I think my final point is the chilling effect of Warner-Lambert's proposal is that everything is characterized as an infringement, and the problem is then sorted out at an account of profit stage. But some manufacturers simply won't enter the market because they don't want to get involved in that. Others will raise their prices, or like to raise their prices to try and ensure they build up a fund in case they have to pay large damages. Pharmacists are going to be discouraged, and indeed there's evidence in the BGMA's submission, paragraph 45 in the supplementary bundle at MS29, that some 70 pharmacists wouldn't purchase the product at all, the generic product at all, because they didn't want to be exposed to the risk.
Which paragraph is that?
Paragraph 45 of the BGMA submissions, supplementary bundle MS page 29, just towards the bottom. Sorry, 80 pharmacies.
I wonder if it's not a bit of a logical puzzle. If you think of trying to apply 60 subsection 1c to the pharmacist, say you have a pharmacist who knowingly disposes of the generic product when the patient's complaint is pain. Now, it seems to be implicit in what you're saying that the pharmacist is an infringer.
With a Swiss form claim, he's only an infringer if the product was made by an infringing process. So unless the manufacturer infringed, he's
Well,
the
quite. Now,
and that's Warner-Lambert's complaint.
So if the manufacturer has made the product in good faith as a treatment for GAD, for example, sold it with a skinny label, and then a pharmacist decides to prescribe it for pain relief, the pharmacist's conduct doesn't retrospectively turn the product into an infringing product.
No.
That's right. That's the deficiency in Swiss form claims, and the deficiency that is eliminated by EPC 2000.
Yes.
That's the whole point. That's why EPC 2000 fixes that hole.
So by rechristening it as no longer being a process.
Yes.
Precisely.
Just ask one question. I mean, in your helpful written case, you've referred to an issue between the patentee and the generic manufacturer, and you've just been discussing the possibility that the generic manufacturer might focus on the appropriate market share and be expected to tailor their production to that share. But is it right to talk of a single generic manufacturer? There's no particular reason why there should only be one. And if there are more than one, then they won't know what each other's production is. So how can they?
They won't, but in practice, the IMS data and other public sources of information give them a very good handle on how much of the product is generic, how much market share each of them has.
I see.
Look, I am not suggesting this is a perfect exercise. These are difficult claims, and there is no perfect solution. But what one needs to do in our respectful submission is make a sensible approach to trying to be fair to both sides and not to interfere with the practice of healthcare. Now, Warner-Lambert's approach
You're not inviting
doesn't.
legislation. What you're doing is you're inviting us to focus strongly on the reality, or the reality of the Swiss form claim and its limitations, and then apply that reality to the strict words of Section 61C and Section 62. And you're saying that creates an outcome which isn't perfect, but that is what the law is.
That is what the law is.
What do you do? This strikes me as completely unreal. What do you do if as soon as the patent on the old use expires? How do you decide what the appropriate market share is for a generic manufacturer?
Because the IMS data, as I understand it, which is gathered, tells you what is being prescribed for what indications anyway. It's not patent related. It's market data. People want to know what the market is for various drugs, and they want to know
what indications it's prescribed for.
Yes.
On a sample basis.
On a sample basis, yes. Again,
but the principal problem with the market share analysis is that it assumes, contrary to the correct assumption, that the manufacturer of the branded product has no interest in supplying for the original, now no longer patented uses.
With respect, Lord, no, it doesn't. It allows for that because the brand manufacturer can make clear what he's doing. He can explain that he's targeting the generic market as well if he wants to. And the brand equalisation deals will have that effect because people will know what they are.
What is a brand equalisation
That,
deal?
I was hoping you weren't going to ask me that. It is where the brand manufacturer offers to supply either all or a larger part of the of a particular customer's requirements and gives him price reductions for the bit he would otherwise buy generically.
I see.
And you'll find it outlined in paragraph 506 of Mr. Justice Arnold's judgment. But I gather they can take many different forms. I wouldn't like to get into that. Now, look, I'm not saying that what we're proposing is perfect. What I am saying is the law is imperfect, and with the greatest respect to your Lordship's powers, you can't fix it. So please don't try too hard.
Well, I mean, the essential problem is that Parliament hasn't amended Section 60 in order to respond to the development of Swiss form claims.
Yes.
Well, yes and no. Swiss form claims were a response to a lacuna in patentability, but because the law didn't allow product for purpose claims, they weren't a perfect response. Nothing can be done about that, but the law has now changed so that gap has been plugged.
Not by the 2004
The EPC 2000.
Yeah. But, I mean, despite what you said, this is important generally. I mean, you said at one point that this was a pretty unique case, but nonetheless, it's important. We should
it's important.
Establish some correct principles,
Yes,
because there may be other disputes apart from this one.
Maybe other disputes, but it's also important that your Lordships keep in mind that the word for also appears in EPC 2000 claims, and anything you say here may have an impact on them, and they work much better without the distortions that you're being asked to impose on them here. Is there anything else I want to say? Lords, unless you have any further questions.
No, thank you very much indeed. Mr. Saunders? Yes.
Your Lordships. I'm going to go back to plausibility, if I may. My learned friend, Mr. Speck, started off his submissions by reference to the Fisher article, to Authorities 18, tab 220. And my Lord Lord Mance noticed that although this article was all about sufficiency and written relatively recently in 2012, there was no mention of plausibility anywhere within it. And that is consistent with the extract from Terrell that we quoted at paragraph 47 of our case at page MS 156. There was no reference to the word plausibility in the sufficiency chapter of Terrell, published in 2011, but now the editors note that it arises in most cases. And my lords, we say this recent fashion, or some might say disease, of plausibility is entirely unnecessary and has gone too far, and this case gives the court an opportunity to nudge the United Kingdom back into line with the EPO and the other EPC signatory states. And connected with this point is the point made at the end of the Fisher article that the scales of justice are finely balanced in relation to the bargain struck between the patentee and the state. And we submit that the courts below have upset that balance by treating plausibility in the way they have, and in a way which is not followed by the EPO or by other member states. And of course, this problem won't disappear when Swiss claim forms die out in 2031, 20 years from the last one in 2011, because the plausibility issue relates equally to the EPC 2000 claim. And so the situation that my learned friend Mr. Silverleaf put on infringement, there is no endpoint to the plausibility problem. And so, my lords, we suggest that the approach adopted by my learned friend on this appeal would tip the balance so far against patentees that much research into second medical uses would be abandoned. And as Mr. Justice Burse noted in the Hospira case, it's often the existence of the patent itself which funds the trials. So if you can't get a patent, the trials might never take place and the drug might never come to market to the detriment of everybody. And of course, my lords, the problem of speculative or armchair patents is not a new one. And for 35 years, the courts under the Patents Act 1977 have dealt quite happily with the problem under the traditional grounds of invalidity without having to invoke plausibility. And that's why we say, contrary to my learned friend's submissions, there is no need to invoke anything more than the standard requirements for sufficiency and in particularly enablement, and that is the key. And I can illustrate this, if I may, by reference to the Biogen case, which my learned friend took you to, which is Authorities 1 at tab 9. It's MS page 1586. And it's in the speech of Lord Hoffman on 46 of the report. And at line 46 on that page, perhaps your lordships would just read that paragraph and the following paragraph at the top of the following page.
Sorry, starting where?
Starting in Asahi at line 46 on page 1586. So what Lord Hoffman was doing here was emphasising the importance of the concept of the enabling disclosure, which he explained arises both in section 14 of the Act and, importantly for our purposes, in section 72, the sufficiency requirements. And this is the key and the only key. And he went on to apply that. And if your lordships, you were taken to the passage on page 1588 in relation to Genentech. And then if I can pick it up at the bottom of page 1588 at line 40, where he said, in fact, the board in Genentech was doing no more than apply a principle of patent law, which has long been established in the United Kingdom, namely that the specification must enable the invention to be performed to the full extent of the monopoly claimed. If the invention discloses a principle capable of general application, the claims may be in correspondingly general terms. The patentee need not show that he has proved its application in every individual instance. On the other hand, if the claims include a number of discrete methods or products, the patentee must enable the invention to be performed in respect of each of them. So I pause here, my lords. It's not necessary to have a principle of general application. As Lord Hoffman points out at the bottom of that paragraph, it's perfectly proper to enable using discrete methods or products as long as each of those are set out. So, my lords, how was that applied in this case, in Biogen? Can I take you to the next page, 1589, and Lord Hoffman summarised the issue before the judge and the Court of Appeal at line 27, and he said, the argument before Aldous J seems to have concentrated on the questions of whether it had been shown that Professor Murray's method was capable of making both HBCAG and HBsAg, and whether it would work in eukaryotic as well as bacterial hosts. And so the issue at trial was whether or not you could make both HBCAG and HBsAg, and that's what the trial judge and the Court of Appeal focused on. And if we turn over, please, to 1590, Lord Hoffman summarises the findings of fact at line 36, and he says, but the fact that the skilled man following the teaching of Biogen 1 would have been able to make HBCAG and HBsAg in bacterial cells, or indeed in any cells, does not conclude the matter. I think that in concentrating upon the question of whether Professor Murray's invention could, so to speak, deliver the goods across the full width of the patent or priority document, the courts and the EPO allowed their invention to be diverted from what seems to me in this particular case the critical issue. It's not whether the claimed invention could deliver the goods, but whether the claims cover other ways in which they might be delivered, ways which owe nothing to the teaching of the patent or any principle which it disclosed. And then he goes on in the next paragraph to explain these two types of claim breadth objection, and he refers to Genentech, and he says at the top of 1591, this shows that there is more than one way in which the breadth of a claim may exceed the technical contribution to the art embodied in the invention. The patent may claim results which it doesn't enable, such as making a wide class of products when it enables only one of those products and discloses no principle which would enable others to be made. And just pausing there, that was the question that the trial judge and the Court of Appeal in Biogen were addressing, i.e., can you make HBCAG and HBSAG, or can you only make one of them? So that was a true width of claim question. Then he says, or it may claim every way of achieving a result when it enables only one way, and it's possible to envisage other ways of achieving that result which may make no use of the invention. And that's the issue which he then went on to determine in the Biogen case. That is the Biogen sufficiency point. In other words, although you can make the products across the scope of the claim, you can make both HBCAG and HBSAG, the claim also covers other ways of making those products which haven't been contributed and disclosed by the patent. And that's not really a claim breadth objection. I prefer to think of it as a claim depth objection, because although you can fulfill the claim across its breadth at the level which the patent teaches, the claim goes further and encompasses other methods which are not taught, and that is the basis upon which Lord Hoffmann found the Biogen patent was invalid. And this was memorably illustrated on the next page at 1592, where Lord Hoffmann recorded the metaphor at line 13 used by the witnesses. He says, the metaphor used by one of the witnesses was that before the genome had been sequenced, everyone was working in the dark. Professor Murray invented a way of working with the genome in the dark, but he didn't switch on the light, and once the light was on, his method was no longer needed. And his problem was that the claim covered all the versions of doing it in the light, as well as doing it in the dark, and that's why it was too broad. And so, my lords, when you come to the last paragraph, the last page of the judgment, which was referred to by my learned friend on page 1594, what we submit Lord Hoffmann was explaining when he said at line 6, Section 72(1)(c of the 1977 Act is not only intended to ensure that the public can work the invention after expiration of the monopoly. That's the question, can you make both HBCAG and HBSAG? That is the simple width of claim point. He also went on to say there are other factors, and that is the depth of claim point. That is to say, does the claim cover, although it can be satisfied in full, does it also cover other methods of making the products which haven't been disclosed? And so, my lords, we say that is how you should understand this passage. There's not some additional requirement that needs to be met by claims such as those in the present case. It's just a simple analysis sufficiency. It's either the claim breadth can either be you can't get all the way from one end to the other of the claim, that's you can't make HSB, C and S, or you can get all the way across the claim, but the claim covers deeper methods, further methods, and those are not disclosed. And so, my lords, we say there's nothing special about the labels that are used to describe sufficiency, classical, claim breadth and ambiguity. They're all just ways of saying that the claim is not enabled. The person skilled in the art can't fulfill the claim across its breadth. And in particular, the claim breadth insufficiency that was dealt with by the trial judge in Biogen, but wasn't part of Lord Hoffmann's reasons for invalidating, and is the claim breadth we see in the present case before you, is just a milder form of classical insufficiency. So in classical insufficiency, so-called, nothing works. You can't get the product to work at all. In claim breadth sufficiency, as in this case, it's just alleged that part of the claim doesn't work. That's why it's a milder form of insufficiency. And of course, the Biogen claim depth insufficiency is a further version which, although one version of the claim works across its breadth, there are other versions claimed which don't. And finally, ambiguity. You can carry out some elements of the claim, but there may be a test, such as the weight of EPO in Kirin Amgen, that you have to compare it with, and you don't know what that is, what the comparison is, so you can't test at all. And so, my lords, where does this take us? This takes us back to Mentor and Hollister. And we therefore refute my learned friend's submission that Mentor and Hollister, the undue burden, the reasonable trials, we refute his suggestion that this is only part of the story, because in the end, everything that the UK courts and the EPO do is to look at the undue burden test as set out in Mentor and Hollister and see if that applies, and that applies to all aspects of the sufficiency requirement. So if you can get the invention to work with routine trials, then it's sufficient, whether your objection is one of classical insufficiency or breadth of claim insufficiency. And it's also important to recall from Mentor and Hollister that this notion of being able to, having to carry out the invention at the priority date does still allow you time to carry out routine trials. You are still allowed to work up what you see in the patent and take the routine trial step. It may take weeks, may even take months. In some cases, it's been suggested to take up to a year where you have to find the antibody. But this is all still sufficient. You can still work the invention at the priority date.
If you have a second use patent, the sufficiency condition will always be satisfied, provided that it was satisfied in the case of the earlier patent for the product. Is that right?
No, my lord, because it would have to treat the conditions for which the second use patent set out. And the question is the skilled person put in the position at the priority date of being able to work the invention?
You accept that you've got to disclose grounds for supposing that it will be efficacious in the new use.
Yes, there has to be some basis for thinking it's efficacious.
I don't like the word plausibility as a description of that process. What do you say?
Well, in the end, it is simply sufficiency, and plausibility has arisen because in the European Patent Office, they're trying to test enablement, the statutory question, and they just don't have the material before them to know whether it works or whether it doesn't work.
Work out how this works. You have a second use patent. Is it enough that the skilled man can replicate the product and he gives it to the patient who appears to get better?
We would submit that as long as there is there's reason for him to think that it's going to work, and so he's sufficiently motivated to do it, then yes.
He can replicate the invention simply by taking the original product unchanged and giving it to a patient.
Yes.
But you accept that he's got to disclose in the patent some reason to suppose that the patient will get better. It's not enough for him just to take the pill and give it to a patient and see.
Well, the invention, my lord, is the idea that this product is good for treating this disease. And so as long as the skilled person doesn't think the idea is implausible at the European Patent Office level, if you give the product to the patient and it works, that is sufficient. You have enabled the invention. You have put the invention in the hands of the public at the priority date by providing them with the means to work the invention. Now, if you were to list 100 different conditions and the skilled person, it would take them 2 years to test each of those conditions in patients to work out which is the one that works. I quite accept that that's a very different set of facts, and one might say, well, it's too much, it's undue burden for the skilled person to look at the specification if there's no data in it at all, and do all the necessary tests to work out whether or not that product is effective. That's a different fact.
Are you saying that unless you've got an inherently implausible proposal, basically you don't need to explain why you think that this is likely to work in the new use?
Yes, then that's the approach that's the approach the European Patent Office takes.
That's your submission.
That's my submission. That is the approach the European Patent Office takes. There has to be doubts substantiated by verifiable facts, and that is, they will only question enablement if there is a reason to do so. And that's why, I mean, of course, if the evidence is adduced that it doesn't work, the patentee will lose the patent for that reason, and the opponent is at liberty to bring that evidence at any time.
Doesn't work, it won't be there.
Nobody's going to produce a generic version.
No, but it may be, in this case, it was open to had it not worked for some elements of the claim, then the respondents could have adduced evidence it didn't work. In fact, they tried to. They tried to do that for post-operative pain, as you'll recall from the pleading, but they abandoned that because, in fact, it does work for post-operative pain. And so, my lords, the European Patent Office is put in a position where it has no evidence of enablement because it's the early stages of the patent. So to test enablement, it is using this evidential test, plausibility, to question, well, if I don't think it's going to work, then it's probably not enabled, and we will question and challenge the patent on that basis. So, my lords, Lord Briggs asked for a little further evidence of the approach in the European Patent Office, and there's a useful summary in the Sandvik case, which is at tab 46 in Authorities 5, MS 3078. And this we reflectively submit supports the submissions I've just been making. So if we pick it up, what Mr. Justice Arnold did here was go through three EPO cases, which had in fact all been discussed by Lord Justice Jacob in the Novartis case. He points that out in paragraph 114. The first one is the Unilever case.
Sorry, can you give me the MS page number?
3078 in its tab 46.
The case name is?
This is Sandvik and Kennametal.
Tab 46.
Tab 46. And this is, the reason I go to this is Mr. Justice Floyd in the Regeneron case, which my learned friend took you to, referred to this. He explained that it was all down to enablement, and he referred to this summary. Paragraph 115, the first two lines is important. In the board's judgment, the criteria for determining the sufficiency of the disclosure are the same for all inventions, that's including medical use claims. And the question is, at the bottom of this passage, the question is whether the whole subject matter that is defined in the claims, and not only a part of it, must be capable of being carried out by the skilled person without the burden of an undue amount of experimentation or the application of inventive ingenuity. And we say this is absolutely in line with Mentor and Hollister and everything we've been submitting. And then if you turn over the page, you'll see 3079. There's a passage, the second full paragraph. The board is asking at the end of that paragraph, the question is whether the patent monopoly be extended to subject matter which, after reading the patent specification, would still not be at the disposal of the skilled person. So again, this is all about enablement. They then go on to go through the factors which are relevant to testing enablement, and they emphasise that what the skilled person is allowed to use is their common general knowledge and trials, and the facts will depend on each individual case. The next case referred to is Mycogen in paragraph 116, and importantly, this is a plausibility case. Mycogen is one of the first plausibility cases in relation to Article 56, inventive step. Nevertheless, the board sets out precisely the same principles. You can see the second paragraph in the quote there, 4 lines down. The question is whether in the light of the disclosure provided by the description, the invention can be performed only with undue burden or with application of inventive skill, and then goes through the various factors, including the use of the common general knowledge. And then on the following page, 3080, just the last 5 lines of the actually go a little further up, 7 lines up, they refer to serious doubts existing. That's the basis for there to be an objection. And they say, however, in all these cases, the guiding principle is always that the skilled person should, after reading of the description, be able to readily perform the invention over the whole area claimed without undue burden and without needing inventive skill. On the other hand, the objection of lack of sufficient disclosure presupposes that there are serious doubts substantiated by verifiable facts in this respect. And that's the magic wording that I took your lordships to in opening, in which Lord Briggs asked where it comes from. It's here, and it's repeated in many cases, and you can see it in the case law book as well in the plausibility section. And I haven't got time to go to that now, but it's Authorities 18, tab 215, page MS 7138. You see the same test being used in relation to plausibility. And then finally, the INEOS case cited here, you'll see just two-thirds of the way down the page, the question is whether you're allowed a reasonable amount of trial and error, and what you're not allowed to do is be made to perform a research programme in order to find a suitable way of preparing the product, and that again is entirely consistent with Mentor and Hollister. So, my lords, and finally, of course, we have the Satinab case, the CML case, which I took you through to opening. I'm not going to go back to, but again, that emphasised the approach the EPO takes is to ask whether there are a priori serious doubts, and if there are, then the plausibility requirement arises. And so, my lords, we submit that plausibility has grown up in the EPO simply as an evidential substitute for enablement, applied in circumstances where the EPO doesn't have before it evidence of actual workability. It's not in dispute that you don't need to have any evidence. There's no need for any evidence to be available in the patent to support the claims. The only way the EPO can therefore judge enablement is to substitute for an actual test of enablement an assessment of plausibility, which it only raises when there is a prima facie case of serious doubts substantiated by verifiable facts. Does it look like it's enabled? But that's all it is, and just because it is used for understandable reasons by the EPO in their examination doesn't mean that it should become an alternative or a substitute for the proper enablement test under Article 83, which the courts can carry out with all the relevant evidence before them. And we say, therefore, if Article 83 is satisfied at the priority date, as we say it is in this case, the plausibility notion cannot add anything to the enablement test, the workability test, which I've talked about. Now, my lords, moving on to the three errors that we say the Court of Appeal made, and my learned friend's submissions in relation to each of them. My learned friend didn't really address you on the third of the errors we say the Court of Appeal made, which was the failure to apply the correct statutory test, that my learned friend had no answer to the evidence that the skilled person could and would carry out the invention without undue burden at the priority date, and by that I referred you to the evidence of Dr. Scadding at MS 1273, the bit that wasn't included in the Court of Appeal quotation, and also the evidence of Professor Wood at MS 1268, where he said he would be very interested to see what the compound did in a range of animal models, and that the skilled person could carry out those tests and would have no difficulty in doing so. And based on these observations, i.e. the data in the patent was enabling. So, my lords, had the courts below had the correct test in mind, they would have accepted this evidence as being determinative of the sufficiency of Claim 3 across its scope.
Is that a matter of expert evidence on which the courts should have accepted, formed a view on the evidence?
Yes, in fact, the courts did accept the evidence, and I'll show you a little later. They just didn't apply it in the right way to the test. That they misunderstood the test of plausibility, right. And had they applied the right test, then it would have led to a conclusion that the claim was valid, even on their construction. My lords, you have my other two submissions, I think, well in mind. The salami slicing point, it's not something which the EPO does, as we saw in the Desatinab CML case. And my learned friend, again, had no answer when the point was put to him that the central pain patients in this case were equivalent to the imatinib-resistant patients in that case. And you'll recall from the text of that case that the imatinib resistance was common general knowledge at the priority date and was said to be a major problem. So if anything, those patients in that case were a bigger and more significant cohort than the central pain patients, which the Court of Appeal recorded in paragraph 59. Central pain was much rarer than peripheral neuropathic pain. So, my lords, we say it's enough that Claim 3 is plausible for neuropathic pain at the level at which it was expressed. And it's no answer for my learned friend to say that it's illegitimate for us to rely on the generality of the claim, the way in which a patentee expresses his claim, the level at which of generality at which he or she expresses it is a choice for the patentee, And plainly, he runs a risk of it being non-enabling if it doesn't actually work at the general level. But of course, in this case, it does, so that can be no answer. Nor does my learned friend have any real answer to the post-published data point. It's clear from all of the EPO authorities, including those two most heavily relied on by my learned friends, Salk and Johns Hopkins, that post-published data is permissible when there is at least some basis to enable the claim, as again the dasatinib case demonstrates. And the error that Lord Justice Floyd made in the Court of Appeal was to focus straight down onto the central neuropathic pain aspect when rejecting the post-published evidence, when the claim is just expressed at the level of neuropathic pain, and there was no dispute on his findings that the claim is plausible, at least for some neuropathic pains, the majority being peripheral neuropathic pain. And, my lords, for those reasons, we say he should have allowed the post-published data to be admitted and to make the difference. And, my lords, we emphasise this doesn't mean, by relying on post-published data, that we're conceding that the invention was only workable later. It worked at the priority date for central pain in animals and humans, and all we're doing with the post-published data is using the results of later clinical trials to back this up. And my learned friend yesterday characterised
the tests referred to in the patents. The judge found that those did not assist in predicting efficacy for neuropathic pain.
I'm not sure that's quite right, my lord. I'm going to come on to that after the adjournment. But if your lordship's focusing on the word predictive,
I'm not seeking to give that a more definitive meaning than basically there's got to be some good reason for supposing.
yes. Well, the evidence was, and I'll take you to it after the adjournment, it's all in the statement of facts and issues, I don't need to go anywhere other than that, was that central sensitisation was involved in the test, in the rat formula test. It was known to be involved in peripheral neuropathic pain, yes. So the skilled person would think...
But there are two stages, aren't there? The first is, what do the tests directly show? Which the answer given by the judge was nothing as far as neuropathic pain is concerned. He then went on to say, but is there some reason to suppose that it's plausible to believe that because there's a common factor here of central sensitization, because it works in inflammatory pain, it will also work in neuropathic pain, or at least some forms of it. That's the reasoning, isn't it?
That's the reason, although the evidence was that the tests were not purely tests for inflammatory pain. I'll show you, my lord, that after lunch. But yes, essentially, that's the reason. He said there was sufficient basis, because it affects central sensitization, to think it would also work for neuropathic pain.
Well, what he said was that central sensitization was a factor in both cases, and that was the unifying
characteristic.
Factor.
Yes. So, my lord, we'll come on to that, but just to finish off these points, my learned friend yesterday characterised the post-published data point as being admissible to rebut suggestions of lack of plausibility. And of course, that's exactly how it's being used here. It's to rebut the suggestion of lack of plausibility. And of course, such evidence would be admissible to show lack of enablement, as we saw in the generics and Yada case. So why shouldn't it be admissible to support enablement? Finally, I'd like to deal with the suggestion made yesterday that we weren't entitled to run the hyperalgesia allodynia point in relation to central neuropathic pain. And we quite accept that we cannot run as a unifying principle for peripheral and central neuropathic pain as we sought to before the judge, as we sought to run before the Court of Appeal. And that was dealt with by the judge.
Not run these as a unifying principle.
For all types of pain, absolutely.
Yeah. That's the point Judge makes at paragraph 349.
Yes, but we're not seeking to do that here.
You're looking for a different unifying principle.
No, we're doing what Lord Hoffman said you can do in Biogen, which is to have separate reasons for separate bits of the claim. If that, you don't have to have a single unifying principle for all aspects of the claim. So we have central sensitization for peripheral neuropathic pain, and that's what the judge found was sufficient, and the Court of Appeal upheld. And then we have, we submit we're entitled to rely on hyperalgesia and allodynia for the central pain element, because it was common ground that allodynia and hyperalgesia were common features of central pain. And I told you about that in,
That goes further than what the judge did at paragraph 351, isn't it?
It does, because he only dealt with it on a universal basis. But if you're allowed to split up these factors, then and I said I'd mention the evidence in opening. I should show it to you, and so my learned friend's got the opportunity to comment if he needs to. But it was put to my witness that it was common general knowledge in 1996 that allodynia and hyperalgesia were common features of central pain. Yes, and that's enough, we say. So the objection to that, we're not seeking to go behind what the Court of Appeal have said, that we can't run. We're not seeking to run that point now, but there is still that point which wasn't an issue, and so we can't see that any objection could be taken to it.
How are we doing in terms of time?
I think I've finished plausibility, my lords. Just two sentences. We say that the Court of Appeal were right in paragraphs 41 and 42 and 46, where they set out the relevant standards, 41 and 42, where they mention educated guess, plausible, reasonably credible, a low threshold, and not designed to prohibit patents for good faith predictions, should not be revoked even if based on only slimmest of evidence. And where, crucially, where the data in the specification is such that the reader finds it credible to pursue the medication for the claimed indication, those are all reasons where a patent should be granted, and if they'd applied that standard to the evidence on this case, they would have found the patent valid. In contrast to the findings of the courts below, every court in Europe and indeed around the world has found this patent valid, and with that I'll just hand up the opposition division decision which my Lord Briggs asked for. In opening. It's only a very short comment, but it at the end of one of the paragraphs they do just explain they think there is sufficient data in the patent.
Sorry, you just said courts around the world have found this
patent valid.
Valid.
Yes. We've set that out in our case.
Yeah.
Thank you.
The sentence in this decision of the opposition division is at the end of paragraph 2.1. This problem is correctly solved by the patent in suit, which shows enough pharmacological data.
2.1.
2.1, yes. Sorry.
Sorry, what do we get out of that? It's a specific act.
Lord Briggs asked for it, and we were explaining that there was no...
yes.
On examination, the question of plausibility enablement wasn't raised, even in opposition. Although the point wasn't directly argued, the opposition division did say the problem is correctly solved by the patent in suit, which shows enough pharmacological data, and they were referring to neuropathic pain.
Was there a challenge on that basis?
There wasn't a challenge on the basis of sufficiency, no. So it may be of limited assistance.
Right. So what is your position about timing afterwards, Ben?
So I need to address briefly my learned friend's appeal and then construction. I don't know whether my learned friend needs the whole hour to reply on his...
You better have a word with each other, because
yes.
I think otherwise, to give him the whole hour, you have to stop at p:30.
I do, and my learned friend Lord Panic, of course, needs to address you too, so
yes.
We are pressed.
Well, it may... Yes, well, we don't want to invite it, but if it's absolutely necessary, we'll consider the position at 2 o'clock as to whether we sit slightly late, but we can't really sit very late. I think the absolute maximum would be quarter of an hour, but I hope you can find a way of achieving it within the original time span. Right.